All right, so I have a definite request from Richard that everybody please make sure that they have muted. Richard, is it a bit better or does it make a difference yet? Yes. I'm going to try. Dodo, can you please just help and see whether you can actually um,
Okay, Karen, from my side, all the candidates are muted, but I'm trying to get hold of our IT so that it can assist because I can hear the
okay.
noise at the background.
Yeah. Yeah, I don't know
Okay,
really how to take. Yeah, I'll just
just
hold
give
on.
me a sec. I'm trying to get hold of our IT guy.
Thank you. All right. How's the sound now? Anybody? Richard? Was there
It's a
Richard?
bit better.
Is it a bit better?
Yeah.
Can everybody hear clearly? I just don't want anybody to have a noise in the background and they are disturbed. Better. All right, let's get rolling then. So I'll carry on. There was a question whether I'm going to share screen. No, I'm not going to share the screen. We are recording the materials, so I assume that everybody will work through the notes. Yeah, so I will just go through them as we page through. So I work as follow. I go through the pages. I talk a lot about what we do in practice because that's usually the way that we learn most. And then obviously, if there's any questions from your side, please put them in the chat box. I will have a look at it as I continue, just to see if there's any questions as I continue. So definitions, that's important words and phrases that we use in notarial practice. And you'll see there's a lot of abbreviations used in your notes. However, note that when we are drafting, no abbreviations is allowed. So a notary public means that in relation to any deed or document creating or conveying real rights of land, a person practicing as such is in the practice or in the republic and relation to any other document executed outside the republic. A person practicing as such in the place where the document is executed. So it is very important that we realize that in previous years, you had to be a notary in the province where you were executing documents. Now it is a countrywide execution, so you don't need to actually state where you are from. The mere fact that you have been registered as a notary um, is all the difference now. So it is within the republic. Sorry, guys, the noise is coming back. I don't know whether it will die down or whether it's just maybe the load shedding. Let's see how we can go. If I have more complaints than Dodo, please, we'll have to have just a look and see what we can do. All right. So let's carry on then. So it is like I say, it is for any. Is it overpowering? Dodo, you'll have to help me, please. When I am it. Hmm.
Hi, Caroline.
Yes. Is it only mine? Yes, Dodo.
Yeah, there is a noise. Casey is coming to assist because I'm trying to
Okay.
check who's making the noise at the background, but I can't see because all the mics are muted here.
Okay. Yeah, let me just see because it's quite quiet where I'm at. So yeah, I don't really know if there's anything that should be interfering. Shall I switch off a bit or do you want me to try and carry on or shall I wait? Okay, maybe it isn't. All right, guys. Richard, I'm going to follow your advice and switch on and off and see how it goes. So I'll be back in a moment.
Did you put them on mute?
Unmuted. Mute, because then it means if you're talking on the from they can't hear.
Hello, I'm back. Can anybody just give an indication of my sound? Dodo, can I continue? How's my sound now? Oh, yeah, I think it's with the load shedding that we're having problems in the data connection. Priyanka, is it terrible or can I try and lecture because our time is really limited tonight?
Colleen, I think you can try and carry on. I think as you speak and it gets worse, but that's my own interpretation. Like they're saying, it's not terrible. It's a lot better than it was before.
Okay. Right, like I say, yeah, I think it is has to do with the connection tonight. Yeah, I usually don't have a problem. 6.510. Thanks, Keenan. I'll do my best to see whether I can limit the sound. How does that sound to you? Is that a bit better or not really? Right. All right, guys, I'm going to try my best to see how we do with the sound now. Yes. All right. Thanks, Nadine, for that feedback. All right, let's get rocking on this. So I'm going to just give us quickly as a head start again. So I was busy with the definition of notary public. Means that we can execute documents in all the provinces in the whole of South Africa. Well, it applies to the ones relating to real rights. So remember, we're busy with real rights where we are executing deeds in the country. So remember, there's certain documents that we have to notarially execute, and then there's the ones that we have to have ready for deeds office purposes. So that is then what we have to keep in mind when we're talking about execution in the Republic. So it is necessary for documents to be notarially registered within the deeds office, like I've mentioned just now, as well as the office of the mineral and petroleum title registration office. It's therefore essential that the notary must know what the requirements of each of these offices are where we are registering the documents. So yeah, so those are the things that we have to keep in mind. In which forums are we busy with and what are we trying to achieve when we are actually working on those documents. So a notary used to be admitted in the court under the Attorneys Act, but that act has been replaced now by the Legal Practice Act in terms of Section 26, if you want to have a read through it. So the important definitions that we have to consider when we are drawing documents, specific instances of what has to be included in our documents, is the places of where we are practicing. So where are you practicing when you're executing? It has to be in your preamble, usually the jurisdiction of court, the seal of office. Usually that's one of the first things that the newly admitted notaries has done is making or having a seal for the offices made. You can have a fancy one that just embosses the documents, or you can have a stamp that you can just freely use anywhere. The embossing stamp is quite heavy when you have to carry it around. Then you get the protocol, which means it's a public document that you have to keep in your protocol register. So usually there's a few formalities that we have to keep in mind when we're dealing with this. And usually when we are executing documents or drafting them, we have to make sure that there's more than one original. So usually when we are practicing as attorneys, we make sure that there's only one original. But in this instance, we usually have more than one original because of the fact that we have to have one for our protocol register that we keep in there. And this protocol is quite important. So if anything breaks down in your office, be sure that that's the first thing that you grab is your protocol once you are a registered notary. The minute is also the original document that's executed before the notary and attested by both the notary and the witnesses. A notary may not have any carbon copies, and that's what I said just now, of any deeds that they have in the protocol or in their minute. So it's important that we have more than one original document when we are being executing documents as notaries. For the purposes of registration, i.e. in any deeds office or mineral rights office, a notary will lodge a signed duplicate in what we call a gross in the deeds office. So usually you will have the clients execute the document and thereafter you will have a copy or a regional copy registered in the deeds office as well. So in both instances, should anything get lost, you'll have an original signed document as well as a backup that we can have or make reference to. You'll see the formal definition there for a gross is a copy of a minute, but instead of having the usual concluding attesting clause, it will end up with the words signed by the peers and the witnesses and in my presence. So the one is more formal. It says where they've been signing so that you can assure that the clients have actually signed in front of you and that there was witnesses actually present when they did. This is for the purposes when you are actually looking at your protocol years after the event so that you can make sure that the people actually were in front of you and that you did attest to them signing the documents in front of you. In other words, you can't have it done online and attest to where you're sitting in your office, something like we are doing tonight. Unfortunately, we're not a paperless industry and you still require that original signature from your clients. Then we have also a protocol register wherein you list the documents that you actually are executing. It'll have a number, and usually within the documents that you are registering, you will number your protocol or you'll follow your protocol number for the execution of the next document that you will be registering or be attending to for registration. So the protocol, like I've said, is like something that you really must keep in safe custody when everything burns down. This is the first thing that you really have to grab onto. So in terms of Section 102 of the Deeds Registries Act, a notarial deed means that the one is attested by a notary public, but excludes any document signed by a notary public for the purpose of mere authentication. So just a slight intonation there as to which document is used where and for what purposes. Just have a look as well as the word deed, which is considered or construed to be to include a certificate by a notary public. It's a document that was signed in front of them. The meaning of the documents, and as they understand it, and that the copying of a writing was compared by him for the original. In other words, you have to make sure that your documents that you have signed are identical in what you are attending to. And then obviously then any notarial act or certificate of noting, presentation or protest of a bill of exchange or a promissory note needs to be executed by a notary and is therefore included in the word deed. And that's what we also register them in the deeds office or the office of the mineral rights. So the functions of a notary for professional conduct, usually it's considered a higher standard of ethics. You are deemed to be a specialist in the field. You also have to incur, or you will incur professional liability for damages arising from professional legal work that you've conducted and if it is found to be any negligence on your part. Therefore, a notary must be at all times professional and independent. And if there's any interest to be earned or that you have in a matter, you'll have to excuse yourself from being the notary in that matter. Otherwise, there might be a fault and then you cannot execute properly. So only witnesses who actually see the appearance or sign or if the appearers acknowledge their signatures in the presence of witnesses, may act as witnesses. Now, what I usually see in offices, it was where the documents will be signed and then we just call in the typist quickly to say, come in quickly, witnesses, and you never see the people actually making those signatures. Remember, when you are doing notarial work, it's important that everybody bears witness to the signature being made and the people actually doing so. So we are custodians of the identity of either the person or the signature that we are attending to. Then also the custody of documents. Just have a look as to which to go in your protocol and your register as above. So the one is usually a thick arch level file where we put in all the documents. The other one is a register that we keep to actually know where to look for it in our arch level file. The responsibilities of a notary is basically to identify the periods, like I've just said. Um, we actually have to act with competency in what we are doing. Therefore, it's a higher standard of knowing the law that is expected of us. Then there's reference made as to the competency of people also appearing in front of you. Also make sure that the people that are executing your documents are competent to do so. And then they start with a young age. So persons under the age of 7 obviously cannot execute any documents. Between 7 and 14 and are competent to give evidence in a court of law, they may execute your documents. No person is qualified to attest a power of attorney or will under which you derive a benefit. In other words, even as notary, should you derive a benefit from any document that is signed, you are disqualified from getting any benefit. So just make sure when you do have any interest in the matter, whether you must excuse yourself or not. Then also we look at a will. Just make sure that when you are drafting wills, you'll see that that is part of the course that we will be doing next week, is that when you are drafting a will, that you are not actually witnessing it, where you are getting any benefit from that will that you are drafting or that is been signed. We're so busy on competency, we're looking at companies then. When we have a company or people acting in a representative capacity on behalf of a company, make sure that you have the necessary authorization. So we'll have a resolution usually from the company saying who may act on their behalf, and those documents are kept in our protocol. And we have to make sure that those documents are originally signed, despite the fact that we're living in a electronically background. Unfortunately, like I said earlier, this is still not a paperless industry. So your authority for any people, any person signing in front of you has to always have a resolution or some form of power of attorney when they are signing on behalf of a company, trust, depending on the entity that is signing in front of you. So a company cannot, of course, escape the liability on the ground that some or other act was ultra vires its powers. So one must just distinguish, and that's why I say there's a few acts that comes into being, and that you'll have to know whether the people signing can actually do so, and what is the conditions for it to be applicable, to be a valid contract or execution of a document that you're entering into. And like I previously said, it's very important that a notary must be at all times be completely impartial. And then the case law is also set out as to how impartial you should be. The matter for Johnson versus the State of France is usually they refer to case law that actually sets out the matter most clearly. Then a notary should not attest any deed relating to a matter in which he has an interest. I've also said, look at the matter for Van der Heever and Khan. And then the other thing that a question that arises usually is whether the fact that the notary is your attorney for one of the spouses makes him an interested party and disqualifies him from attesting an anti-nuptial contract. Just have a look at that case that is noted there from Ratani versus Maharaj. And Henochsberg, however, expressed himself quite strongly in this matter as to whether you are or is described as an interested party or not. Then there's also, in practice, the owner's or grantor's notary. You draw the documents and attest such deeds. You must make sure as to which documents really requires a notary execution, because not all documents requires that, but um, the law says that there's some documents that is excluded or specifically for notaries to be executed. Um, yeah, so that is where there's no objection to a notary attesting deeds signed by deaf, mentally impaired or blind people. So provided that the peers understand what they are doing. But to safeguard yourself, it is suggested that you obtain leave from court if you are not sure to execute a contract without reading it to the appearers. Um, Especially when they are deaf, they can't hear you when you're reading it. Blind people can hear you, but mentally impaired people again, one usually will look there as the representative capacity of somebody acting on their behalf. Notaries, in common with other professionals, must have secrecy regarding the affairs of their clients. That's something that follows the attorney-client privileges. And then the only exception of the rule is where it will actually further a crime to be committed. Therefore, that type of information you may share with the necessary authority. Then the admission, removal, or suspension of a notary. Just have a look as to reminders of the provisions of the Legal Practice Act that came into being after the 1st of November in 2018, and how you actually, your application has to be drawn to be admitted as a notary in a court of law. You have to read carefully with regard to the rules that's ever changed. We have to do that in consultation with the LPA usually, or the one for your province, as to what the specific requirements may be for the application, and then obviously with regard to the reference fit and proper that is referred to in that specific act. And then in support of the statement, you'll see that the documents has been included in your pack. Sorry, Kim. Seems that it's coming and going. We must just have a look that our documents, or the documents that is included in your pack also gives you an example of your application that is to be brought and the documents that needs to be attached to such application. Just make sure always that it is compliant for the time wherein you bring it, that it has lain for an inspection, and that you make the necessary provisions or statements within your application. If you have to make payment to the LPC where you are, just make sure that you get the relevant banking details for the province that you are practicing from. They get that from time to time. So, like I said, there is a draft example for that attached here too. Well, the uncertain or in the in the instance where you haven't acted in the normal course of business and you have been negligent, you may be removed or suspended if you commit a breach of any of the above relating to professional conduct. And then also your LPC for the specific division or where you're practicing in, they can have disciplinary proceedings as well. There is also instances where the High Court has suggested that those hearings should be heard for certain people practicing. Um, well, if you are found to be negligent, the Legal Practice Council will investigate the facts on which you are charged on, and there is case law. You can have a look as to the Law Society of Cape Town, Good Hope versus Frank and Warshaw. Just make sure as to what is considered professional conduct and how that works. Then there's ethical standards. Kim, I'm so sorry. Just, yeah. Is it really that bad, Kim? Hmm. Right, let's carry on. I'll try and get it a bit softer for you. So the ethical standards and requirements applicable to a notarial practitioner. In law, ignorance is no excuse, although it's a mitigating factor. Have a look at the Incorporated Law Society of Transvaal versus Kuiper. Then we get to the applicability of stamp duty. Remember, stamp duty was also abolished, but Section 103 of the revenue laws. Just have a look at the things where it is applicable and where not. I think the time for the period has lapsed. I think the long-term leases as well, that was signed within 2009 by now, will have all ended. Yeah, still applicable to lease agreements. Then we get to the authentication. Mm. Ayanda, I'm assuming that you have the course material and therefore you'll be able to follow me through the course material. There is no slides to be shared. Right. I'll talk a bit slower. Usually it sounds a bit better if I talk a bit slower. Right. Great. All right. So then we get to authentication of documents. All right, guys, give me a moment. All right, guys, let's just check that. Sound check, everybody. Now it's the time to tell me how you hear me. Yes. How much better is that? Can you hear me? Is that right? I'm on voice reduction. Yay. Even I'm clapping hands now. Thanks, guys. Appreciate it. Right. So let's get into the tough stuff. The first was just luckily on the introduction. Yes, we get it eventually right. So we're on to the authentication of documents on page 22 of the course notes. If you do want to follow me, you'll see that I just talk about this. I do this every day. So anything that you need to ask, please put it in the chat box me and will answer your questions as we go. So the authentication of documents is something that you as a notary will work with every day. I want us to make sure when you are getting instructions, do you need the documents for use inside or outside of South Africa? And that will determine as to what you will request and require from your client. And then you'll follow the High Court rule number 63.1 for authentication as defined. When applied to a document, the verification of any signature therein. No slides, unfortunately, Kim. Yeah, let me just leave it at that. So, yeah, unfortunately, none. All right, so for this now, maybe for next week, I will consider giving you some slides just to keep you occupied. Yes, back to rule 63.1. So what happens when we are authenticating documents? That we are busy with. So the process of authentication is that you are using it either overseas and you are authenticating the signature of a client, or you are identifying a client for the presence or in the presence of a notary and it's going to be considered, or you consider the authenticity of that signature. So one has to consider as to what you are actually looking at and what your instructions will be, what needs to be verified. So if you are using documents or requesting documents from outside, so what happens usually in practice is that your clients are situated outside the country and you need them to sign documents that you'll have to use inside the Republic of South Africa. So then there's certain procedures that you'll have to follow. So if it's for litigious purposes or because the client is overseas and you have sold a property and signed, you have to follow the procedure for Rule 63. So they've given you an example there of Australia as to however it's divided and situated and what may be necessary and what not. But let's just go through the rules first so that you can see how they fit into one another. So with Rule 63.1, it describes as to how do you actually verify a signature. So this is for use, or what we do with the documents within the country for use outside of the boundaries of South Africa. And this is also when we are so it's execution outside, the definite distinction in those two. So the signature of the person executing the document shall be authenticated by a magistrate, then a magistrate, the registrar or assistant registrar of the High Court, then a commissioner of oath, a notary public, or justice of peace. And you'll see that there's different people authenticating different people in this line of authentication. So you can see it's also a lengthy process. People don't understand that it takes time because it has to go through all of the channels for authentication if it's to be used in another country. However, if it is a part of the Hague Convention, then there's other rules that should be applied. But remember now, for purpose of your exam, and what you need to concentrate on is when we are executing these documents outside these 5 things, you can see who actually commissions and confirms the authentication of a signature. And then in the instance of a notary, is that we usually file our signatures with the High Court or the Registrar of the High Court, so that when we send documents for them for authentication, it's already on file. And then the process is cut a bit short in the country. So they also mentioned that for you in the notes, that the signature of a notary may be authenticated directly by the Secretary of the Department of Justice, and we lodge a signature, like I've rightfully said now, with the Registrar of the High Court. And then you'll see that you can also do that with the embassies and consulates overseas, and they give you a few of the examples that you can actually lodge it with their embassies as well, and therefore it will be recognized as such if you have to authenticate documents for use outside the boundaries of South Africa. Then we get to the rules for signature of a person executing the document. So usually when you are authenticating either a person, so you're identifying the person or his signature, remember you have the two that we have to identify. The signature must be appended in the presence of a notary. Remember, the notary cannot be busy with other work, and you send out your secretary to see to this signature of the client deposing the signature. The signature must be acknowledged in the presence, and that's very important, in the presence of the notary, unless the notary is satisfied in its fact that the signature of the person who executed the document. And this is also difficult to say that you should do this because of the fraud that is being committed in the country. People do funny things these days. And I also say, being a notary, you have to make sure that the person who's actually signing does it in front of you so that you cut out the chances of fraud being committed. Remember the highest standard that's actually required from a notary, and therefore you have to really make sure of whoever is in front of you and who is actually signing the document. Then once you've basically established that you're happy with either the identity or the signature, you will attach your certificate of authentication or your seal to that document that has been signed, stating that you have basically identified and that you are happy as to the identification procedure that was followed. There's an example under 7.3 of the notarial authentication certificate as to how you are going to give it. Just remember in the last few months that has changed we have to add our LPC numbers to all the documents that we actually do. So if you are registered with the LPC, then you usually just attach your number. Remember, it's not the practice number, it's the personal number that you are registered as with your different LPCs. You can have a look at the notarial authentication certificate. Usually in practice, we have something on system. Just make sure that you don't copy and paste to such an extent that you make unnecessary mistakes. Remember, negligence is not permissible when you are a notary. So your certificate of authentication of a notary signature, like I've said, it is usually verified with the registrar of the High Court by virtue of a specimen that has been provided to them. And then below is also an example of what the registrar of the High Court will then issue. So what happens in practice is that we usually prepare the certificate and the registrar will only put his signature and stamp to that, confirming that he knows your signature and that you are actually registered with him. Then the rules for authentication of documents executed outside the Republic of South Africa. Remember, it is a document in the context of a deed that we need to register within the deeds office or the mineral office. So it's a specific document that we'll have to have attested for the purpose of verification of any signature. And remember, this becomes important if it's done wrong. Sorry, who's my info guest? No, you're not allowed to attest online. No, not at all. Yeah. So if somebody, let me just clarify that, if somebody is overseas, then they'll have to follow the procedure, and I'll get to that quickly as to how they actually do that then. We will give them instruction as to where to go to have either their signature verified and their identification, depending on whether the country that they are based in forms part of the Hague Convention or not. So no online situation allowed when you are actually executing notarial deeds. So remember again, when we are talking about identification and documents that's signed overseas, usually it's used then for formalities where we are registering that specific document in a deeds office. So if the authentication is not done correctly, the document will not be useful and you'll have to do it again, because the deeds office is really sticky about documents that has been signed overseas and the formalities that is attached to those documents being used for registration purposes. So it's important that you know first and foremost the formalities as prescribed by the Deeds Office or the Deeds Registries Act and the Sectional Titles Act for the Deeds Office registration purposes. Really, really important. Have a look at those, but I'll get to it just now. So we have to have a look quickly at Rule 63.1, which actually says that, well, it is referring to a document that needs to be verified and a signature thereon. Rule 63.2 will tell you how it should be done when it's done outside of the country. It gives you the whole spiel of those 5 places that it needs to go to, even if it's overseas. And then coming closer to home, just looking there at the exception as to how it's done in the United Kingdom. Usually the UK have a different prescription as to how they comply with it. And then a notary public, we shall be shown by certificate or any person referred to in paragraph A, B, or C of the diplomatic or consular office for that foreign country. So every country, one has to be sure as to how it's done, how the certification process works, so that when you get your document back, that it's actually a useful document. All right, and then just see that usually it's the consulate or the embassy that certifies our documents or the correctness thereof. For the instance, our notary public certification will be accepted if these documents are signed in the UK, Northern Ireland, Zimbabwe, Lesotho, Botswana, or Swaziland. Make a note of those 5 countries. Easy stuff. It's one of the countries where you don't have to follow the rules of authentication. A mere signature and stamp or seal of the notary will be suffice for use of the document in one of the formal offices in the country. And then usually it also says that the commissioned officer of the South African Defence Force, in the case of a document executed by any person or active service, that would be also then accepted as enough authentication for the purpose of Rule 63.2. Then we look at the Rule 63.3 that says that if any person authenticating a document in terms of sub-rule 2 has no seal of office, you can actually write it out by hand. So no need to fret if you have basically forgotten your stamp or it's not carried with you. You can just do the writing by hand. No stamp then required. You can have a look at Rule 63.4, and then we get to Rule 63.5 again. So a power of attorney that's executed in the 5 countries, as I've mentioned above, you basically just need to have the authentication that is provided in the power of attorney and authenticated by a notary, and then obviously your 2 witnesses. There has to be competent witnesses, remember that. It cannot just be a child under the age of 7. There has to be somebody competent in law to testify. So usually that's the measure that I usually say to people. If you ever have any doubt, can this person stand up in court and testify? That would be your rule of thumb, basically, to follow with your competent witnesses. Then we get to the apostille. I think in comparison to Rule 63.1 with all the rules for authentication, the Hague Convention makes it much easier that if you have to authenticate documents, you just drop the apostille, you send it off to the High Court, they just basically give you your stamp and seal, attach it to your documents, and it's all nicely, there's a nice ribbon, and then usually a seal of office attached to that, and that would be the end of your authentication, and you don't have to go through the long process of authentication. Once again, remember, authentication, depending on whether you use it in South Africa or out. I just want to quickly see. Then if there's no consulate or embassy, they'll have to follow the long method of authentication, but also have a look then at the list of Hague Convention countries. There is some of the countries in the US of A that prescribes to the Hague Convention, and then the apostille will be good enough delivered by them and the person so authenticated to sign an apostille from those countries. So you just have to make sure when authenticating whether that person is at or the country is part of the Hague Convention or not. And that's why it's important to know, one, is it for use inside South Africa, outside South Africa, and are you part of the Hague Convention or not? South Africa does prescribe, so for a lot of use in other countries, we just attach the apostille to a document, send it off to High Court, they stamp and seal, and then we can use it outside, or our clients can use their documents outside the country for whatever purposes they may require. So like I've also said, each state which is a signatory to the convention was requested to designate a reference to its official function, and the set competent authorities who are competent to sign that set certificate. So just make sure who belongs to the Hague Convention, and you'll see that actually we give you the reference to the internet or the website www.hcch.net for the conventions and status, because that's the thing that changes basically on a yearly basis. So often we check it just to make sure that the rules haven't changed or the countries haven't changed. Just make sure every time that you are actually working with the right type of authentication when you are busy with this document. Then obviously with authentication, I've touched on that, is that your apostille or any means of certification will be attached to the documents that is so needed for authentication with that nice, it's a green ribbon usually that we use, and then it's light green, not more than 5 millimeters, and it has a nice seal to it. In other words, they still use the wax, and it's like attached to the documents, and you cannot really separate the documents. So you have to decide also what documents should be included in that documents that you want so authenticated for use overseas. Unfortunately, overseas, you pay for each and every document that you have to have authenticated. So you have to give clear instruction to your client as to what documents you need to be authenticated, so that to save them costs as well. You need to be cost effective, having regard to the cost implication of having anything authenticated overseas for use in South Africa. Then we also get to the Commissioner of Oath, which is also considered to be a notarial practitioner. So the rules for being a Commissioner of Oath, and I see in a lot of offices, we have ladies or secretaries wanting to be Commissioner of Oath. Just remember, if you are nominated to be Commissioner of Oath, usually you have to write exam. You first do an application, then you do the exam, and then once you're admitted as a commissioner, you may charge no fee for actually being a commissioner or executing the documents as such. You may not administer the oath if he has an interest in the matter, and an oath is administered by the deponent when he says, I swear that the contents of the declaration are true, so help me God. And an affirmation is where he only says that the documents are true, and usually this is where they have a problem with saying, or that they don't want to say the words, so help me God. Then there's certain questions which forms part of your commissioning that's also set out for you. And then, yeah, like I said, it's usually when you have an objection to taking the oath that you'll just have an affirmation. And then the deponent must sign the declaration in the presence of the commissioner once again by either making a mark or his signature. And remember, it's always the right hand if you have to make a thumbprint. And then usually you'll have to write that it was the right hand thumb that was used in the process of making a mark to that document. So just be very specific, manner, place, and date of taking that declaration. I just want to go back to the question in the chat box quickly. If you're born in the UK, needs to register child's birth in South Africa and go to school. Sorry guys, I'm just reading quickly through this SA man and a Cameroonian woman. Just give me a moment on that question. I just want to finish with the commissioning, and then I'll get back to that specific question as to how you go about getting those documents then authenticated. All right, so that is basically that. So except for the question in the chat box, is there anything else that you'd like to know? Oh, was that good enough answer for you? Great. So then we are down to the historical background of the Office of the Notary. You'll see that it really comes from many years ago. It still stems from the Cicero notaries that became so respectable that the order was named by him as the Honestus. You can see that it was a great honor from very times or a long time ago to be actually considered a notary because of your honor that was highly regarded in this. And that's on the history of that. All right. So any questions? And then you'll see that there is a draft application attached to notice of motion when you want to become a notary. What I'll appreciate for next week around, if we can just read through the notes, that if I go through it, if there's any questions that we can work on it, and then obviously I'll answer questions also as we go along with those documents. So you'll see the notice of motion is set out there. Nothing is set in stone. Remember, it's an ever-changing science. So just see that you're always adhering to the necessary conditions as it's applicable at the time when you are making your application, and what should be in your founding statement and what should be left in and left out. Remember, there's time frames wherein you have to file and serve. One, you have to file with your LPC. and then on the date that precedes the date of hearing of the application by at least 1 month for inspection by the council. So there is certain of these statements that you have to put into your application and your founding affidavit that is required. But that is merely as to your application to be allowed to practice then as a notary public. Because he mentions also make of your, you have to be an attorney to be admitted as a notary. So reference also has to be made to that. Yeah. All right, so if there's any questions, I will move on to the structure and drafting of notarial documents. Anything quickly on authentication that somebody wants to quickly note for me or ask?
Hi, Carlene. I don't know, you said you'll come back to my question in the
The Cameroon one.
Yes.
Yes.
Thank you.
So, all right, no, not a problem. Thanks for the reminder. So, if it, so home offence will need the authentication document. So it's not a strict. We'll follow Rule 63.1, and then in that area, if they don't prescribe to the Hague Convention, in other words, so if they prescribe to the Hague Convention, it will be an apostle from the area in the USA where they are living that will actually issue us with a certificate. So we'll have to go check to see in which area in the states they are residing. Do they prescribe to the Hague Convention? And then whether an apostle or Rule 63.1 is applicable or not. And remember, that document will then go through all the long way of authentication if they don't prescribe to the. Yes, Simongile, you are quite right. That is what you will be doing. It's verifying a document signature and the person usually. So we have to make sure that the one is actually the other as well. Sorry, I'm back to the Cameroonian one. Is that clear enough for you quickly? So first you check out the Hague Convention. Do we prescribe? If we prescribe, usually we attach an apostille or we request them to attach an apostille to that. And the authority that is actually nominated by that state will then sign off a document like that. In other words, you won't need an embassy or consulate. Otherwise, if they don't prescribe, you have to follow the long route of Rule 63.1, where you go from the one to the other, depending in what state you are. All right, great stuff. All right, so then we're on the structure and drafting of notarial documents. So in this module, we need to learn how to draft or define a notarial document, a notarial deed. What is the advantage of a notarial deed and document? List the notarial deeds which are registered in deeds registry. Remember, not all documents need to be registered. The drafting, what is the formalities and the rules with regard to documents that needs to be drafted or executed for registration purposes in a deeds registry, the structure of a notarial deed, the description of the parties, the properties in a notarial deed, very important, and understanding the responsibilities that the notary assumes when executing a notarial deed. And this, again, I'm going to try and explain to you mostly by what we do in deeds office, because if we are compliant with the deeds office requirements, your documents will be accepted for registration. And like with any other document that's registrable in the deeds office, if it's not compliant, you'll have to go back to your client and have it re-signed in terms of the deeds office conditions or the conditions that they want in your document. So that is very important that we are compliant with the various acts, that when we are drafting the documents, we don't have to do it again. All right. So let's quickly just go through the definitions again. Notarial document, it is, you can draft it in any way. There's really no format that's prescribed for a notarial document as such. However, a notarial document is one that's executed before and attested by a notary. All right, name, place, all of those things that is important, and the fact that the parties appeared before a notary needs to be stated in the preamble, usually of all the documents that you are drafting. So those are the requirements, and I would suggest for exam purposes that you actually memorize the preamble to any agreement where a notary has to sign. So it is whoever appeared in front of me on this and that day, before notary, my LPC number, um, or practicing at which town, province of Gauteng, for instance, and then you can carry on. So those four things is really the important things when you are drafting your notarial deed. So although we say no formalities or format as such, the content is really important when we get down to notarial documents. So that is for a notarial deed. So you have to comply with Section 102 of the Deeds Registries Act. And that means just that the deed then is attested by notary public, and it does not include a document for signature that's merely authenticated by a notary public. So there's different documents that we need for different institutions. You have to make sure in which forum your document is required to actually draft in accordance with that. So the advantage of a notarial deed. So notarial or notaries are deemed to be specialists in their field. So we expect that you actually can draft as well as in that field as well. So it's a presumption that you are aware of all the information and facts that is reflected in the document and that they are true and that you have satisfied yourself to the correctness of that, as well as your client's identity usually, as well as a signature if it's necessary. And if your client suffers damages as a result of negligence, they may hold the notary liable. So we have really a lot of faith that's been put in us as notaries to do things the right way. So in terms of the Deeds Registries Act, that's the DRA, the following documents must be drawn and attested by a notary and registered in the Deeds Office. The provisions of the Deeds Registries Act are applicable, and then we have to look at the registers of circulars as well as the resolutions. Yeah, you'll have to have a look with regard to antenuptial agreements, and these are the things that really you have to concentrate on. Antenuptial agreements, personal servitudes, predial servitudes, and we'll later on during the course actually go into depth with these different servitudes that you are registering. Same goes for long-term leases, the ones that's registrable and not. Termination of those leases, and remember, if you register in terms of, or it's notarily executed and registered, it has to be cancelled in the same fashion. Cancellation cannot happen in another manner. So if you register by way of notarial execution, you'll draft a document for cancellation to cancel that agreement that was so executed as well. So those are notarial bonds that we also are going to look at, Section 61, notarial agreements that we are entering into. Then again, also it becomes really important when we're looking at servitudes, notarial deeds of real rights, where we're extending schemes. So our Sectional Titles Act becomes important. Real rights of exclusive use areas, and then servitudes with regard to common property. And this is then where your knowledge of the Deeds Registries Act becomes really important. I don't know, maybe by way of raising hands, is there conveyances online tonight so that I don't have to go too much into the conveyancing side, because it becomes really important that we have a basic understanding of the conveyancing practice to really understand the registration process of notarial documents. Anybody quickly, please. Conveyances? Simongile? Only one? Anybody else? All right. All right, for those of you that's not conveyances, please stop me, because when we get to the description of parties, properties, and all of the rest, then we have to make sure that we really know how it works. Like I said previously, you can be drafting your little heart out, but if it's not acceptable to the deeds office, you'll have to go back and re-sign with your client and reconsider your document that you've actually then drafted for registration purposes. So Deeds Registries Act, really important. And if you can get some experience in the drafting of a notarial deed for registration purposes, also an advantage for you. So let's get down to the drafting of a notarial document. Remember, your language has to be unambiguous. You have to make it clear as to what the intentions of the parties were entering into this agreement. And that's really what you want to give. So if there's any uncertainty or dispute after the fact, that you can actually say this was the intention and therefore this was the wording that was used and that is the intention. And the court will also then go, they actually, from the court's decisions, they will actually then, they will have a look as to what was drafted and how proper it was. It's actually quite concerning to see what lands in front of courts these days with documents that was drafted, and that you actually have to have a look as to the skill of the draftspeople in those instances. So the grammatical construction and ordinary meaning of words one has to adhere to, and just have a look at it, that you give no other meaning to that, that gives effect to the true intention of the parties. It should be the real nature of the transaction. So your terms and conditions should be clear as to what you are doing. I'm on page 38 info. All right. This is a bit ahead of me. Anyway, so we are ambiguity. Yes, you have to be clear on it as to what your intentions are. Then the general words that you are following by specific words. Just have a look at the, remember, this is all conditions that we put into a notarial Kim. I'm sure Dodo attended to that. Can we hold it over for a bit later on and we can just make sure? All right. So the interpretation of a document as a whole, remember that that's one of the things, is that you look at the document as a whole. Every clause and term is read in conjunction with that. Remember also your headings does not really give the direction, it's the content. So what we find in detail for what has transpired previously is where people draft documents that's registered, but the heading does not agree with what the content actually states. And then the court will actually give the meaning to what the content was and not as such the heading. The heading will be disregarded for all means and purposes. So you have to make sure that your contracts that maybe and the words that you can include or the conditions that you may or may not include in your conditions or your contracts. This is a bit of contractual law that we are just working on tonight, so that you know with the drafting skills as to what is required from you. And then remember there's implied terms as well. And then terms would be implied by contract or by court if it comes to the conclusion that such implied terms are necessary in order to give effect to the intention of the parties. Remember, that is what they will tell you, is that the implied terms is to give effect to the intention of the part, and then only. For the rest, your wording is really important. Then also joint liability. So unless otherwise stipulated, the liability of co-obligators is joint and not several, and the rights of obligees are held in common. Have a look at that case that is given there. Just have a look at the joint liability becomes important when we are dealing with estates, where we have a joint estate usually. And then, like I've previously stated, the consequence of the time of entering into your contract when you are executing notarial deed also becomes important for matters of dispute, especially when we are executing anti-nuptial agreements. Sometimes you get people that wait until the really last moment before they get married, and then time is really of the importance. So not only the place and date, but the time will be necessary, because some of these documents need to be executed before the very act, like for instance, executing of a anti-nuptial agreement. Really, really important time at that stage. Language, also avoid long and cumbersome sentences. Remember, the longer the sentence, the more the chances are that you are contradicting yourself, and then you make it for words that will be actually not regarded as being written as all. So they also say that we shouldn't be referring to archaic verbal or verbs when we or vocabulary when we are actually talking or writing down. Um, for instance, note the notary is a very old profession. Therefore, one must know that there's some things that is traditional when we are actually drafting documents. So you'll see that they actually say that one can substitute the I hereby nominate, constitute, and appoint X as my agent. You could simply say that you are appointing them. But with tradition comes the nominate, constitute, and appoint. People like all those words to make sure that all the ends are covered as to how you get your nomination done. Then we are down to the rules applicable to the preparation of notarial deeds. Deeds Registries Act. And that's why it's important that we have an idea as to how it works in Deeds Office. We'll see when I get to the drafting of documents. There's certain formats that you have to comply with, even when you are writing exam. So if we say you start halfway down the page, you start halfway down the page. Otherwise, Deeds Office will not register it. So you have to get into that mode where you exercise how the document should be drafted. Make sure of your format that you are drafting in, also very important. So they give you the rules as to how you should be doing this. But like I say, practice makes perfect. You have to practice this. I can preach that you have to start halfway down, upper half page was the left blank for endorsements, what your margins should be like. But this is something that you have to practice because in the end, when writing exam, you'll write this out. So please comply. Yes, please, Richard. Especially when drafting certain of the documents, you'll start halfway down the page, heading protocol number first and foremost, so that we can see there was a protocol, and then we'll start with what your heading is, usually your notary deed or whichever one you are executing, and whoever came and appeared in front of you. So the first four things that I usually say is important for the start off on any of your drafting documents. Very, very important is on formalities. You have to comply with the formalities. So the structure of the notarial deed, they give you the forms that actually sets out the commencement and the conclusion. So also for exam purposes, I would suggest that you memorize your commencement and your conclusion. It's easy things, and that's something that we just see that you can do, and that you know that those things are to be inserted in any notarial document. All right, so it doesn't really matter on format, just have the content right. So if you can't remember halfway down or not, at least have the content right. Then we know that you are on the right track. So it should be also noted that in terms of section 61, 3A of the Deeds Registry Act, every notarial bond shall disclose the place, date of execution, and the place where the notary practices and where the debtor resides and where he carries on business. But that is most applicable in your bonds that you are registering, is that those things will come to the fore as to you say where they reside, place of business, or for the purposes usually for sales and execution, or when you actually have to place people in default because they have not complied with an agreement that they've entered into. So important notarial deed, commencement, conclusion, make sure that you have those things in it. And remember, as of late, your LPC number needs to appear on your document. I see that the documents makes provision for it in the commencement, but just as a safety measure, you'll see that where it says notary public at the bottom, under that we usually just put our number again, just to make sure that the Deeds Office doesn't raise notes with regard to our LPC numbers. That is something that we have to adhere to quite strictly also in the Deeds Offices. All right, so these are the things that you have to keep in mind. On content, at least, make sure that you have the basics in place. Then we have an agent acting, a representing party to this agreement. You also have to state the details of that representation. In other words, by virtue of a resolution dated so-and-so entered into by the directors of this company, so authorized to sign on behalf of, and you give the company details with the registration number that goes with it. Remember also when executing a document like that, you will need the original resolution that goes with it. And the instances where you are dealing with, say, a sectional bond, you will actually not lodge your power of attorney, but you'll keep it in your protocol. And where it is a full title bond, then obviously you will also lodge that power of attorney. Important for your protocol, though, if mention is made, then you have to put that resolution also always the original, right? Just make sure that you have the specific authorization set out as per the instruction, or actually the comments given to you on the layout and structure. Very important on this part of it. Then we get to the description of the parties on a notarial agreement. Remember, also you have to follow deeds office rules. Unfortunately, if that is incorrect, you'll redo it. Deeds office, like I say, they are non-forgiving on this. So if you are dealing with a natural person, this is where it becomes important as to who is the persons on the other side of the table. If it's a natural person signing your agreement or entering into your agreement, you will refer to the full name and surname, identity number, and a marital status. All right, and like I've previously said, also you'll refer to the representative capacity if it is on behalf of somebody else. So also if it's a natural person, you can get somebody to act on behalf of yourself to go and execute a document on your behalf. That is not uncommon to do that. All right, so also make mention and take note, no abbreviation when you are dealing with notarial documents, either in deeds office or in the mineral rights office. No abbreviations is allowed whatsoever. They'll actually make you retype the page if there's any abbreviations used. So just make sure of that. Then we refer to unmarried persons usually. They are divorced, widowed, or never married. I usually joke and say any of the others is not really a status. We're dealing with a status matter, and being a notary, you should be really aware of the status of a person dealing with them. But yeah, there is the instances where people really feel strongly about being described as either a widow or divorcee. Then I would say that you can refer to that, but that is not really the practice at this stage. We do refer to them as unmarried. We do take note of the fact that they are divorced, for instance, and we ask for divorce order, settlements, agreements, and all of those as supporting documents, but we still refer to them as being unmarried. Act number, no, we won't say the number dot. We will say act and then say, for instance, 1957, just after that, no, just number. You'll have to type it out. If it comes to registration number, you'll have to type it out for you. It's registration number. No abbreviation allowed, all right? That is the unfortunate thing that you have to get used to typing or writing out the full word. Then we are also taking note of the fact that people are either married in or out of community of property. So we look at the status matters now when we are describing natural persons. So they can be either unmarried, then married, in or out of community of property. Remember, we don't make mention of the accrual system if they are married to that. You're either married in or out of community of property for description in our documents. And then if it's in terms of the laws of another country, we have to ascertain ourselves as to which country it is actually then that we are referring to, make sure of the status of the country. You'll get the Republic of China, for instance, the United Kingdom. There is certain descriptions that you have to refer to specifically for other countries. It's not just the Republic of South Africa, for instance, to describe things. So one has to be really sure of the name of another country if you have to describe them. And then usually there's a difference in the acquisition description and then basically the financing side of it. So if you should distinguish in the giving a power of attorney. When we are describing the power, in other words, I already own a property, for instance, I'll make mention assisted, or it's actually then described by in terms, or I'll be married in terms of the law of another country, assisted by my spouse as far as needs be, and I'll give my spouse's full names who is giving the assistance for the specific transaction. If it was for both parties owning a property, for instance, you will describe both parties with reference to both partners into separate divisions in your documents that you are describing the parties to. So that really leaves also for specific draftsmanship when you have to make mention of the laws of another country. These officers really are sticky with the descriptions of other countries as such. So you have to make sure that you know what the country's real names are. So it's also essential that the notary then asks pertinent questions when client presents the notary with a foreign marriage certificate. And then the most crucial one, in which country did the husband originally reside at the time of the marriage? Because obviously that will have an influence as to which law then governs that specific contract or the agreement that you are working at. Remember, we are not specialists on the laws of other countries, and hence the description that we are referring back to the other countries, and we are giving rights to the other person, assisting the spouse that actually has got the property or not. We always have to look at that. So they also say that the same principles is applicable to persons married in terms of the Matrimonial Property Act, and then also partners in terms of the civil union. We'll get to that just now. And then you'll see it's also dependent upon whether there's an anti-nuptial agreement in register in terms of the Civil Unions Act as to how we will describe them, or whether it's a partner.
Carleen?
Yes. Yeah,
sorry,
sure.
I think, yeah, before I fall further down this bus, I just want to understand. I'm sorry, it's a little bit difficult to follow without these notes. This, where you typed here registration number, where do we write out full, you say we must write Matrimonial Property Act registration number 88 of 1984.
No. So this is merely for the description of a company, for instance. This is just an example where no abbreviations will be used. So people, yes. So I'm not referring to the specific acts that you'll be referring to. In other words, in answering your exam questions, you are welcome to write act number so-and-so the way that you've done it. But when we get to the drafting of the document specifically, you have to write it out. There's no abbreviation allowed at that stage. Sorry, dear, I wasn't sure as to your question there for that instance. Is that all right with you? Maybe?
Okay, so, sorry, just say that clear. When you write it in the exam, you need to write the word number out fully, not NO full stop. You write number out fully. But the registration number that you're referring here to is like a company registration number.
Yeah, so when we get to the description of the various parties, I'll show you just now, as to you'll have your company name that you write out, and then below that usually you'll write registration number, and then say for instance the 1998/00729/07. And in that instance you'll write out it in full. For the rest, when you're answering questions as such, you may use it. So with answering questions, it's something different to drafting. So when we get to the drafting of documents specifically, you are not allowed any abbreviation. All right?
Got it. Thank you.
Okay, sorry. No, not a problem. I just had a Friday, but nonetheless, I get carried away when I do this. I love notaries. Anyway, so then we get to the different forms of the description of parties, and that's the one thing that you really have to make sure of the description as to how you will describe your party, because it's inevitable that the document that you are going to register needs to have the correct party description. You cannot falter in that way. You cannot deviate from the way that the deeds office requirements actually stipulate it should be. So please make sure especially with your certain contracts, you'll see the servitude. Any place where you have to have dealings with the deeds office, you'll have to follow the prescribed manner of describing any party to that. So they've given you examples now on page 43 with regard to where there's no anti-nuptial agreement registered. And this is now just for the sake of just being clear on this. So if there's no antenuptial agreement registered, we are married in community of property. The specific uh, examples I'm giving here for you is with regard to civil partnerships where there is antenuptial agreements registered or not. That's just the difference between the two. So that is what they are trying to make clear for you in that paragraph if you didn't understand that clearly. So just make sure that you know the difference. So we start with unmarried, married in community of property, and then we will start with the civil union partnership where you either are married in community of property that you have a agreement or no agreement, or where you have one that is registered by virtue of an anti-nuptial agreement. And then obviously you get your legal entities that you have to have the descriptions of. And then right at the very bottom of page 43, they refer you to people married according to Muslim or Hindu rites as to how you will describe their marital regime. So remember, we always start with Maria Gonzalez, identity number written in full with her ID number, and how are they married. So is she married, unmarried, or well, start with the unmarried or married in community of property. Yeah, and then I'll just give that description just now, and then the married out of community, but marital status is always then given at that stage. It's different formats, but let's not get ahead of ourselves. And the same goes for the Hindu marriages regime too. So instead of writing unmarried, you will say married according to the laws of Muslim or Hindu. They also say you can refer to them as being unmarried, but most of my clients that is married according to Muslim or Hindu regime will ask you for reference to be made to that. And then further on, the Recognition of Customary Marriages Act that gives recognition to customary marriages, we must also keep in mind, because then people are described indeed as being married in community of property. Yeah, and then giving, it gives further rights to the people that is married within certain regimes. And then they refer to minors under the age of 7 as to their contractual capacity. I think I have made mention of that previously, as to how they may or may not sign it. Their description will be a minor. So the acquisition of rights, you will describe a minor. Say, for instance, it is Sunny LaRue. Identity number, if she has one, or if she only has a birth certificate, she'll be born on whichever day she was born on. And then she'll be described as a minor. In other words, she is receiving rights. Where she is giving rights away, then either she'll be assisted by her parents or guardians to do or contract then in that instance. She cannot give her rights away without assistance. That's in the instance of a minor, all right? And then also we must just take note of the importance of Section 18 the Administration of Deceased or Estates Act, required additional authority from the High Court or the Master actually, depending of the value of the asset in question in respect of an alienation or mortgage of immovable property owned by a minor. What that just says is that, so now I have acquired the property as a minor, and my parents has assisted me, or I have gotten this. Let's leave the assistance away for now. So I've acquired the property, but now we want to bond it. Say, for instance, it's a financial, there's financial difficulties, and we just need to get a bond as security over it. We have to show cause then to the master that it is in the minor's or to the minor's benefit that we actually do take out a bond over the property. Remember, that's a diminishing of a minor's rights, and the master is the supreme guide or guardian of minors in this instance. Then we get to a mental patient that has no contractual capacity. and where a curator has to be appointed by court to act on behalf of such a patient within the ambit of the powers that has been given to him by court. Remember, a mental patient will not be able to give you instruction. Reference should be made in your description with regard to name, surname, capacity, authority, and the letter of authority issued by the master that was so issued. You will actually also then confirm to the correctness of that detail that you have given. Also, it will be a twofold description. So firstly, with a mental patient, we will first describe the details of the curator and thereafter the details for the person that is a mental patient. So we'll have two descriptions in one for that specific document. And then also remember the Master of the High Court that appoints the executor for deceased estates. Executor will then sign on behalf of the deceased estate. A lot of people think that even before an estate is reported to the master, that they can sign on behalf of a deceased person or his estate. That is not correct, and those documents has to be either rectified, or actually it will be ratified first and foremost, and the recital will have to be changed if it was contracted by the deceased during the life or course of his lifetime. But that will also follow when we get to wills and the registration of those type of documents. So yes, next one. All right, if we go back to the Bandili. So your question was if it's married out of community of property, no, then we don't mention the spouse whatsoever. Remember, that is one of the advantages of an antenuptial agreement, is that you are married out of community of property. You don't need the consent of your spouse, and therefore spouses are not mentioned. Then Kim, is the position from... Sorry guys, I have an interference there. Somebody is online. All right. All right. Is the position if a minor is emancipated? If a minor is emancipated, remember, then they're considered to be a major and will be described as such. So they'll cite them as a normal adult usually. With regard to the emancipation, you'll present your court order usually before you actually draft your documents with specific reference in made to your emancipation order. Remember, you will raise all alarms if you are acting on behalf of a minor without assistance of the guardian or parent. So those are things that you cannot just put on the sideline. You have to have your supporting documents. Also with your deceased estate letter of authority, remember when executing those documents, you are certifying to the correctness of the information that you are providing to the deeds office or the institution that you are dealing with. Yeah, so let me just go to that married out of community of property. Usually the question arises if we are married out of community of property and we buy property together, then we are cited in the same document. In other words, then mention will be made of both spouses and we will describe each of one of them separately. In other words, I will say Tim Noakes, identity number, married out of community of property as a number one. And then as number two, I will say Sarah Noakes, identity number, and then also married out of community of property. And that will be the description of my parties to that specific document. So it depends on how we are dealing and who is actually in contracting as to whether we will be making mention of both parties or not when married out of community of property. Different scenario when we get to spouses married in community of property, but I'll discuss that in depth when we get to antenuptial agreements as to how we do that, because that is also a nice comparison that we give there. So then we get down to the persons in representative capacity. And then remember also a trust is not really an entity that we can describe as either a natural person or as a legal entity. It's somewhere in between, and therefore we have to make sure that we are acting within that specific ambit and parameters of the Act for trusts. So you'll see that the names and capacity of the trustees that will appear before the notary must be stated, and all the trustees must appear before the notary unless one trustee has been authorized by all the others by virtue of a resolution taken at a meeting, if the trustee makes provision for that. So remember, it's really important, mostly if you can, and this is really a consideration, if they can all sign, let them do so that there is no dispute later on as to the authority that was given. If the trustees are in separate locations, Sibongile, then most likely we'll have this provision of authority that was given, and then we'll have to make sure that the authority was indeed given. I always say I will need a original signed power of attorney by one of the other trustees if they don't appear personally. It would be practical for them to appear. Yes, definitely it will be. If it comes to that, say for instance, we are executing a deed, we will ask an attorney or notary in that area where that specific then trustee locate or is residing or situated to sign in front of a notary public at that place specifically. So they don't have to travel. We will send documents to another notary for execution. That is always the if an original signature is required. So that is some of the resolution or solutions that we can offer if your trustees are not situated at the same place to appear in front of your notary. All right, so that is with regard to your representative capacity. I have touched onto legal entities as to how we would describe them, and then you'll see specific mention made of that registration number I typed out for you as well. Sibongile, yeah, the power of attorney, usually it is a resolution that we do for them, depending on which type of document you are talking about. If you are looking or thinking about an exclusive use, it will be a power of attorney, definitely that needs to be signed originally by them. We will not execute if we haven't seen an original power of attorney. So depending on your type of document, supporting documents will be either or, depending on what your purpose is of your drafting. Always make sure of that. So yeah, power of attorney, and then also resolution, depending on the situation of your contract. Then other bodies or persons, remember we can also have clubs entering into agreements, voluntary associations, churches, and trusts. These are things that you describe as such, not necessarily with regard to numbers that is registered, but you describe them, who represents them and acts on behalf. So it's always a representative capacity then comes into play, or the specific church name. So it will be the Democratic Church of Africa, or whatever the situation is as to the description that will be used. One must just ascertain yourself as to what the proper and full name will be for the person or the entity then acting on behalf of the body or person as such. And then we get down to married persons. So when the notary then deals with natural persons, except if they are dealing in a representative capacity. So say for instance, I am married out of community of property. I'm not in the country anymore, but I've given a power of attorney to my brother. Then my brother may act on my behalf and appear in front of another notary to execute documents. So that is possible for a natural person to give a power of attorney to somebody else to act on his behalf, and that person acting on behalf, his marital status is not necessarily required, but Deeds Office in some instances has asked for that. So when you are drafting the powers of attorney, I always say for interest and of the sake of not having to go back to your client for an initial or signature, make sure that you basically cite all parties in full. In full meaning name, surname, identity number, and marital status, so that we know from the start as to what the situation might be for applicability with regard to your marital status. Right, that is representative capacity. Then again, we must keep in mind if it's a joint estate, we must sign a power of attorney. That's also important. In other words, if I am married in community of property, may my husband then sign on my behalf? And what type of power is then required, for instance, to do so? And remember, this is where we need to know the Matrimonial Property Act, look at the Act and the regulations 43, 44, with regard, and then specifically 15 and 15A. Sorry, I forgot about those. But then also giving the identification is very important, has the description and consent of parties being married in community of property, really important. And then also make sure that you know when the people are entering into your agreement, whether they have a right to encumber a property. In other words, do they have rights to actually take out a mortgage bond or to give a right of way? Make sure of that power of attorney that is required or the consent required by another spouse if married in community of property. So we go back then to the Matrimonial Property Act 88 of 1984, very important in the description. All marriages concluded after 1 November 1984. Also, about 2 weeks ago, there was that important um, judgment that was given with regard to certain of the Matrimonial Property Act's consents that need to be given and how that will be introduced. But I'll also get to that when we deal with anti-nuptial agreements. So, yeah, so all marriages entered into after 88 of 1984. Various sections of the Act were amended, and the Chief Registrars issued Chief Register Circulars 12 of 1993 to know the amendments and the effect of them for deeds office purpose. In other words, it has to do with your description of your parties. In the olden days, before the Act, we would describe somebody with regard to having marital power or not over a spouse. It has been abolished in totality. So therefore, we don't have to deal with marital powers anymore when making a note as to how we are married. So those type of things were amended with the Act that came into being. So the MPA has 4 chapters, and most of them, I think we deal with 3 of them specifically when we are dealing with notarial agreements. And because we are registering anti-nuptial agreements in the deeds offices, it becomes then important to know how people are married. Then chapter 1 then introduces the accrual system. I'll jump over these because I'll get to anti-nuptial agreements just now, and we'll deal with this in depth. Chapter 1, marriages out of community of property. So all marriages are considered to be out of community of property with the accrual system applicable unless it's specifically excluded. All right. Then the marital power was abolished in terms of chapter 2. So no deed is applicable with, there's no applicability of that anymore to any deed. And then chapter 3 governs marriages in community of property with regard to the consents that needs to be given to parties within those marriages. In other words, we now have got equal rights if we are married in community of property. So we can, by consent then, bind the joint estate. Well, they say without the consent of the other party. So what would happen in practice is that, say for instance, we want to buy a property, the one spouse can decide that he would like it. Remember, I'm talking about being married in community of property, and he will enter into the agreement. But in terms of the act, the spouse will have to give written consent to this act to give effect to this agreement. So section 14 and 15 then becomes important with regard to the powers that we have, the agreements that we can enter into, and the diminishing of rights that we can allow and not allow for when we are actually dealing then with certain agreements and the consent of the spouse. And that is very important, the consent of that spouse. So you'll see that they make specific mention of section 15.2, the consent that's required for performance of the act contemplated in paragraph A, B, F, G, H of section 15.2. and it has to be in writing, attested by 2 competent witnesses or by a commissioner of oath. So in most instances, our documents makes provision for witnesses, but that place can be assumed by a commissioner of oath as well. Then no witnesses is necessary. So it's the either or, either the witnesses or the commissioner of oath that will actually sign to that. Remember also, where we have to obtain the written consent of the other party, it has to be duly attested by 2 witnesses. That is the only way that we can do that. And when we say attested, that when we get that consent, those people have to be present when signing that consent. Once again, we are making sure as to the identity of the people signing the consent, and then obviously it's necessary for deeds office purposes to have 2 signatures, otherwise your documents will be rejected if you Yolanda, I'm going to page 47 now. Right. So then you just have to have a look at the note that is raised there on section 52A of the MPA, that's the Matrimonial Property Act, that has relevance only with regard to when we are giving rights away. In other words, when we are basically signing for a property that we are buying, then both parties need to sign. Simongele, I will just continue or busy. Yeah, I'll finish while I'm busy and then I'll come back to your question with regard to the laws of other countries. Is that all right? Right. So, married in community of property, remember the written consent in terms of section 15.2a has to be obtained. This will be in case where property was transferred. Oh, and then there's the exception to the rule always. So the exception to the rule where we don't get both parties mentioned in a deed is where the other parties married in community of property was excluded in terms of certain provisions of, say, for instance, a will or a bequest that was made. So we'll then describe the party as married in community to Sarah Parker, excluded in terms of the last will or testament of whatever person then made the will and said that the property was to be made a bequest to another person. So just have a close look at that. Yeah, so you can exclude another party when they are married in community of property. Sibongile, just to get back to your question quickly. So the equal rights, we're not taking away, but because we are not experts on the laws of other countries, we're giving, well, we're taking note of other countries' rights that may be given to the spouse, and that's why we have the assistance going. So even if documents, well, if they are concluded outside, it doesn't really make a difference. It depends on how you are married as to who has to sign the documents. The laws are still the same. So if we are where the husband resides, yeah. So that would really be the indication. So the dissertation still would be, let me go to Tim Noakes' identity number, and if he is married at the or is married according to the laws of Greece, we don't know what the laws of Greece may be. Then we'll say assisted by Sarah Noakes as far as needs be, so that both rights are covered, just in case that country also takes note of the fact that they may have estate in community of property or a joint estate. So we're not experts. We're not sure about the communal or the rights that you have in another country, and therefore the assistance will be applicable when we are doing a power of attorney, for instance. So where I'm selling a property, for instance, I will say hearing assisted by the spouse, full details as far as needs be, just to make sure that we haven't given rights away that we're not sure about. And that's the laws of another country that comes into play, but only in that instance. So then we're on to section 17 of the Deeds Registries Act. where we are working with immovable property, real rights, and notarial bonds that form part of a joint estate that shall be registered in the name of the husband and the wife. So remember those documents, and I usually try and explain it by virtue of the example. If I buy a property and I'm married in community of property, and I don't sell both parties, which part of the property will the husband then get? And the wife will most likely not move in. So both parties have to be mentioned when we are registering a bond, when we are buying property, and it forms part of a joint estate. Exception to the rule, there's also always exceptions to the rule, where there is a transfer or cession or the registration that takes place in the name of partnership, in which one of the two spouses are involved in his capacity as a partner. So that would be a partnership, would once again be the exception to the rule, where you are married in community of property, and then you won't make mention, or you'll make mention of the wife, but in a lesser way. We will say Tim Noakes, identity number, married in community of property to Sarah Noakes, and that will be the end of story. Just so that we know that he is married, and yeah, that will be your only reference to her. Then just have a look at section 17.1. When it becomes relevant, we're dealing with grantees. In other words, I'm giving a power of attorney, and this section became effective in 1987. When people that were married in community of property acquire immovable property or rights, it must be registered in the names of both parties or spouses. And then if it was before that, yeah, so if you were married before or after 1984, a marriage in community of property, it doesn't make a difference. The description of the parties is the same. All right. Yeah, it's always the married in community of property. We're looking for both names, both IDs, together with the relevant description. And then we get to the examples of the descriptions of the grantors. And here we must make it, I always say there's somebody giving away his rights and there's somebody getting rights. So the grantors would be the one giving away the rights, grantees would be the ones receiving rights. When we are giving away rights, there's a full description that's required with regard to the parties, their representation, if necessary, or authority to do whatever they are doing. So remember, when we are giving away rights, we want to make sure that we're not giving away more than what we're entitled to, but that all parties are also covered by the rights that we are giving away. Just look at that one for being unmarried. Rita is a Rems, identity number, and she's been married or cited as being unmarried. And like I say, if they really feel strongly about being cited as divorcee or divorced, or whatever, we can do so, but it's preferable to just refer to being unmarried. Then we get down to a person that we are describing as that they don't have a valid ID or they haven't been given or issued with one. In terms of Regulation 18 of the Deeds Registers Act, the conveyancer then in that instance is usually has to give a certificate stating as to the fact that he has made sure that there was no ID given. And the purpose of this would be to ascertain whether this person is an alien for intents of purposes of the Act, because certain provisions then prohibits you from buying property and registering property in the name of an alien or persons considered to be an alien in terms of the Act. So it's important when we actually get a person saying, I don't have an ID, why don't you have one? If they only have a passport, we'll refer to the date of birth, and then we will give a description of the marital regime as per the norm. But then yeah, we have to also lodge with the Deeds Office that specific regulation just to confirm that we have actually ascertained that they are not in contravention of the Act and able to buy property in the country. All right. Right, then we're getting down to people married out of community of property. I'm on page 49. Just have a look as to how Craig Black is being described as being married out of community. That is where Craig Black is the only person buying this property. if Sarah Jones was buying with him and they were married, then we would cite him as number one, married out of community of property. Sarah Jones would be the second one, married out of community, and they would be half share owners or 50% owners of the specific property that we are then so transferring. All right, and then just have a look at that marital power that has been abolished now, giving equal rights. So nothing, we don't have to make any reference now anymore to marital powers that was given. But you do get old deeds that still make reference to those powers. So then it said that if a property is registered in the name of persons married, which marriage is governed by the laws of another country, provides the grantors, well, then you have to follow the provisions that they are set out at the bottom of this page then. So just have a careful look then of this as to how it is set out. And remember, it's duly assisted by the spouse, by her, as far as needs be. All right. So that we make sure that all the rights are covered, because we don't know what happens or how marriages are governed in Zimbabwe. And that's why we will describe them as such. All right. If both parties are selling, we'll do a double description like they've done here. So this is in the instances where we are giving away rights. We will do it like this. So we will mention both parties giving away rights. We are obtaining rights on acquisition. It will only be one of the two if one of the two is buying the property. And you do get people buying for investment, where only one of the two spouses is buying property. So you have to distinguish between when we are getting rights or whether we're giving them away as to how the parties are described then. All right. And then, like I've said to you before, if there's any exclusion with regard to people being married in community of property, then we'll make mention of the fact that you are married in community of property with a slight reference to the spouse. So you can have a look at Henk Klomp, identity number, being married in community of property to Sarah Klomp. And that's usually when it's a partnership that's been registered. This is how we'll describe them. We also do this when it's in terms of a will where parties are excluded. We will actually then recite them or cite them as being married in community of property to the spouse. Then also have a look at the marriage in community of property. So there's a distinction between the first Henk Klomp marriage and the second one. So in the first one, it's usually in a partnership where we have a slight mention, but there's no interference from the spouse in the partnership. In the second one is where we're buying property and we're buying it, say, for instance, for the family. It's now our residence. Then we'll describe it as married in community of property to each other. No, the notary may not assist. Definitely not. All right. Sibongile, I'll get to your question, but definitely no assistance by a notary in any of the citations. Yeah. The spouse may be conflicted, yes, if there is ulterior motives, but that's why the law covers the person giving away the rights or the person then actually executing the documents to have a look and say it's assisted by the spouse for security reasons. That's why we actually do that, all right? But no, the notary cannot assist. If you have any interest, remember, then you have to actually excuse yourself from the matter. Then 7.4.7.2 deals with grantees. If the property forms part of a joint estate of spouses married in community of property, and then they just give you an example again of the marriage in community of property. So remember, when we're married in community of property, equal rights, and usually we cite both spouses first, identity number, and then we say they are married to each other, all right, in terms of the act. Important, mention made again, Customary Marriages Act, considered in terms of the Deeds Registries Amendment Act as being cited in community of property. And then there's a lot of other exceptions to the rule. Saying further that although parties may be married according to customary law, the marriage might not be recorded in terms of the provisions of legislation. And this may create a lot of problems. So it doesn't take away from the validity of any of those marriages. It's just that one has to then be very clear when you consult with your clients as to how it was done and what was done, so that you can actually note and make notes as to why people are cited the way they are. And if they are married, then according to customary marriages, that rights are given to both parties then in this instance. We'd rather give away more rights in this instance where we, instead of giving away a right or taking away a right. And then there's mention made again of the regulation 18 compliancy, and then there's reference to the Alien in terms of the Aliens Control Act 96 of 91. If anybody was wondering as to the citation of that, and then just to make sure that you are protecting yourself, the conveyancer or notary should obtain an affidavit from such person stating as to why and the reason as to why he is not an alien or why he doesn't have it. Also then be very you have to be very strict with regard to the permits. If you want to transfer property or give writing on the strength of any permits when acquiring property, remember a temporary residence is not sufficient for purposes of acquisition. And you can't rely on a work permit either. It's a residence permit that is required. Also, people that comes to visit the country, you get a visitor's visa. They can also, for purposes of visiting the country or having a holiday home in this country, they can buy property. The prohibition in the Act is merely against the purchasing of property, so that you cannot illegally occupy any property. So that is just to make sure that everybody's rights are kept safe. I'll get to those customary marriages just now with regard to polygamy. We will get to that when I deal with the rest of the descriptions. Is that all right with you and Paul? Great.
Yes, it's right. It's okay.
Thanks, Paul. I'm so glad that you are still with us. I'm worried. Do anybody need a break? Sorry, I've been talking non-stop. I don't know whether any one of you need a break. Are we all fine? Great. So parties married in accordance, then we get to parties married according to the Civil Union Act, number 17 of 2006. Remember, there's also certain formalities that we have to comply with. The parties have to be of the same sex, be 18 years or older, and then this union will be recognized by way of further marriage or civil partnership in accordance with the procedures described in the Civil Union Act. Then there's a description of that civil union partner, and then they can also be married in community of property or out. So depending on whether an antenuptial contract has been entered into. And remember, you must always ask them as to how they want to be described in the document before you start drafting. Some people want to be referred to as partners, other people want to be described as spouses. So those are the things that you have to take cognizance of when drafting an antenuptial agreement. So so this is in the instance when antenuptial contract has been entered. It will be the same as a marriage out of community of property. So your first one is with regards to in community of property. Both parties' names again with regard or reference being made to the Civil Union Act that you are entering, or the marriage that was concluded in terms of that act, but that there was no antenuptial agreement registered. And then the second example is actually where they are married out of community of property with an antenuptial agreement having been entered into and executed. Then there's the exceptions to the rule. Once again, partnerships, wills where we exclude the partners or the testators would say, I bequeath my property to my daughter, but not her husband. So then there's a specific exclusion, and only the daughter's name will be mentioned. And then we will say, we'll transfer the property to Sarah Klomp, married in community to a hen clump whose marriage is excluded in terms of a will dated whatever, we'll have a proper description of the conditions of that will, excluding a person from acquiring any rights in terms of that specific contract. Okay, Kim, that's fine. All right, so that was partnerships for you. Grantees again, married in community of property, and then that is basically describing partnerships. So remember, partnerships usually throws people a bit off the bandwagon as to descriptions. Please practice the description. It is always useful just to fall back on somebody that you know or the description that you know off by heart. Remember that partners married in community of property are dealt with in section 17.1 as an exception to the general rule, which provides that property which forms part of a joint estate must be registered in the names of both parties. What does this mean? So if I am part of a partnership, I'm excluded then if I have no interest in that partnership whatsoever. Section 17.1, exception to the rule. So and you also do not disclose the partner's respective shares in the property. So when we refer to the parties, say for instance, we're buying as in community of property, we don't make sure that it's 50-50, or where there's two parties buying a property, we won't say it's an equal shares or an undivided share. We'll just say that the parties are buying a certain property. That's all. No mention made to any shares whatsoever. Remember, we're always looking at the commercial value, and then some things are assumed in terms of the Act. So if we do a deed search for people buying property in community of property, then if you do a deed search, you will show a 0.5 share that you have. So the deeds office will refer to that 0.5 share, although no mention has been made of that in your deed that you have actually registered with the deeds office. Also, when you are doing your transfer duty receipt or application, therefore, we don't make mention of that 50% ownership that you'll have. Actually, when you are on the program to SARS, it will ask you, so what is the percentage? But when you get the receipt, there's no mention made of it. And then the SARS program is also very nice in the sense that it holds you accountable for the percentage that you'll fill in for the people either giving away the rights, so that you can always calculate up to 100%. So if I'm selling the property, I'm giving away 100%. If we are married in community of property, it will be a 50%, 50%, say for instance, when we're selling. And if the buyers are also married in community of property, we'll have 4 people on our transfer duty receipt for buying and selling the property. So that is not stated, but you can see as per the party description that it is understand or deemed to be a 50-50% share that is so held in a property. We're looking at minors and unborn children again. Minors can definitely acquire properties or rights. You actually see a lot of people wanting to make it easy for their children, so they give it to their children or they sell it to their children when they're buying properties on their behalf. There's only the one exception in terms of Section 25 of the Deeds Registers Act, which deals with children to be born or to be born. Just have a look at the description of a minor acquiring rights. Remember, we don't make mention of any assistance. We can give away the rights to a minor and they can only take it. They can give it or they can give it, but they can't give it away. If the minor has an ID number, we must use it. Otherwise, use the date of birth. The problem now arises if we are disposing of that property that the minor got, then we have to take note of Section 80, subsection 1 of the Estates Act, and it may not be alienated or mortgaged by a minor's guardian, tutor, or curator, except that the curator or tutor may only do so if authorized by a will or a written document which has been nominated, and in the case of a guardian, only he may do so. All right. And then we're looking at values when the guardian may do so. So then it's a property of less than 250,000 with the guardian. And then, well, the guardian can sign on behalf of the minor, but then we have to get the consent of the master of the High Court. If it's above 250 and we're selling or encumbering a property, then we have to do this by virtue of obtaining a court order to authorize or dispose of such a property. Remember, we're looking after the interest of a minor when we are doing so. And the master's consent or court order applicable must be lodged. Always important, the deeds office actually endorses any document with a MN note. So if you ever draw a deeds office search with an MN note, you'll know that it's a master's endorsement to look after the minor's interest that has been registered for that minor. And therefore, you'll have to get the master's consent if you want to deal with that right or encumber that right. So the deeds office will definitely look after the deeds of the minor's interest if anybody has overlooked the right that was given to the minor. And then in a lot of instances, you know, minors do turn 20 or 18 at some stage and they become a major. And then the master's consent won't be necessary anymore. And then obviously we just, you know, will lodge a conveyance certificate to that effect, saying that the minor has now become a major in between all the events, and therefore, are we aiming to finish? At least I'm going on to chapter 3 as well, Richard. So I will try and give you a quick summary as we go on. Anybody else also a problem with load shedding? I will try and finish it in the next 20 minutes or so. If you, because I know the signals then gets haywire once load shedding starts. So that is the situation with regard to minors and endorsements. Insolvent persons, remember, law of insolvency, important when we are dealing with this. It has to do with the competency of the parties that we are actually dealing with, and we are citing them. Remember, insolvents cannot act on their own behalf. They need the assistance of a trustee or a liquidator. And also, it will be cited in terms of the letters of appointment and authority to do so. So also take note of the law of insolvency when you are drafting documents in this instance, and also your citation. Very, very important, the citation. And clients will not say to you, listen, I have been declared insolvent. It's something that you come across in deeds office. I'll raise the note saying that there was an insolvency noted. Your client is actually buying or selling without the consent, and you'll have to withdraw all your documents from deeds office, and you'll have to start afresh, either in trying to obtain the consent of a trustee or liquidator, or the liquidator, or even the can then say no, that they don't want to continue because it was done without their consent. So have a look, page 57, with regard to the Insolvency Act, how they can and cannot deal, what needs to be done with regard and documents that needs to be lodged, and then also take note of rehabilitation. I know a lot of people think that insolvency just falls away, but if you're dealing with property transactions, a notice to rehabilitation needs to be filed at least with the deeds office. Otherwise, the insolvency note will keep being raised, and you'll actually have to deal with the rehabilitation every instance where you are dealing with property so held by either insolvent or the estate. Yeah, so insolvency, law of insolvency, very important. Have a look as to the consents that need to be obtained with regard to insolvents and unrehabilitated insolvents, as to whether they can actually alienate or sell property. So it is allowed, but with the consent of the trustee or liquidator. Very, very important. These officers, I think, well, not I think, they will definitely not allow you to transfer without the consent being in place or the necessary rehabilitation orders being filed. All right. Just have a look at the citation on page 59 when you get to the estates and the letter of appointments. When you get to the ceased estates, I'm busy with the citations at present, and the vesting of property. Yeah, so that is the one for deceased estates. Yeah, so if you're insolvent, unmarried, and then with regard to letters of appointment, it will be in the citation. Remember, when we are dealing or looking towards exam, citations important. We look and see whether you could actually do these citations, because the deeds office will not allow registration if the citation is incorrect. And therefore, it's very important that we give attention to the citation. Then also, when we look at trustees, um, very important as to the notary must satisfy himself that the trustee has been duly appointed, and you must keep copies of those orders prior to drafting your documents. Make sure that the authorities are in place. Otherwise, you're putting yourself at risk for not having your due diligence when drafting the documents. If a trustee disposes of properties otherwise than by sale, just make sure that you are not benefiting one creditor above another in the case of insolvents. So, and that's why it's important to make sure as to what the situation is, who has authority to sell, who gives the consent, and who must put their hand to paper in the end if you have to deal with this. And then if it's necessary for a trustee to sell property before a second meeting of creditors, you can apply to the master for his authorization to sell the property. And then usually the master will give his consent by endorsing a power of attorney as well. So one must just have a look as to what is required as to the necessary consent and how it is actually then endorsed, or the documentation given in you know, proving whatever the predisposition might be. Then we get down to the estate's description. This is now where people have passed away in estates. Yeah, and then the other one that we are also looking at specifically on this page is where we are dealing with legal entities. So remember, when you're dealing with a legal entity, you have to have a resolution signed by the board of directors, regionals usually for your protocol, if possible. And then, yeah, just have a look at the specific description. You'll see that proprietary limited is written in full, no abbreviation allowed. I know people love to just PTY limit, but no, we write it out in full, the registration number as well. Yeah, reference to that. So once again, just make distinguish between when you are selling. So if you are selling a property that's owned by a company, it will be the description or citation in the first instance. In the no, Kim, yes, you're right. No PTY limited or LTDs. You have to write it in full. CC, you can, yeah, there was a stage where we had to write out CC, so closed corporations, but that has now reverted back to CC. But for companies, proprietary limited and limited has to be typed out in full. Yes, no CC, no abbreviation allowed. That's the golden rule. If you're not sure, type out your closed corporation as well. You cannot be faulted on typing in full. Then I was basically busy with the distinction between buying and selling property in the names of a company. Have a look as to when we are giving away rights. Remember, there's always the acquisition in comparison to the giving away, we're selling off. When we are selling, we need to give authority for our right to be selling off certain rights. In other words, I'm giving away, and therefore I need to cite whose authority we are doing that on. When we are buying, we are obtaining rights, and therefore we don't really need authority, although for our documentation purposes, we'll do make mention of who has signed the documents of acquisition on our side. But usually the property description in the deeds will just be referring to the property or to the company registration number, no reference to the authorization of that. All right, same goes for the CC, you'll see there as well. So when you are selling a property registered in the name of CC, you'll have the same preamble than Jan Els in his capacity as a member, duly authorized also by resolution of the members passed at Joburg on whatsoever, and you say your Jan LCC registration number, whatever it was. But when you are acquiring, it's only the simple format that you'll use in saying that you're giving rights away to ABC shoes and a registration number. Sorry, guys. So then we have a look at what is corporate. Remember that you also have to describe them properly. They have also a citation that you have to follow, banks, insurance, and associations. The guidelines is usually as per the companies that we have just cited, and follow those rules. You cannot really go too far off what is right and wrong when you are doing that. Then we get down to trust. Trust is one of those things that I can just say to you, please have a look at the Trust Property Control Act. It's one of the shortest acts, but this is where they sink you usually, is what you can and cannot do. Remember, a letter of authority has to be issued when a trustee wants to act on behalf of a trust. If there is no letter of authority, you cannot even ratify both theory and drafting, dear. So, so when we get to exams, both drafting and theory questions, getting back to trust, remember you cannot ratify. A letter of authority has to be in place. If your letter of authority wasn't issued when you transacted, you'll have to redraft. If a trust is created in a will, application in terms of section 40 for the endorsement of a title deed to the effect that the property is to be administered in a trust as directed in a will. So that's by mere application then that you bring such or do a transfer of the property. Then the distinction again, property acquired by an inter vivos trust, it's to the trust in an ordinary manner, and the grantee will be described as the trustees. Remember, I always say that there's a distinction between giving and receiving, whereas if you're describing a trust, it will always be the trustees for the time being of the animal farm, trust registration number, IT, whatever your letter of authority states. So it's important the trustees for the time being is added to whether you are giving away your rights or whether you're receiving rights when you are acting on behalf of a trust. Please make sure that those things are definitely in your citation when you are doing your transfer of a property, or citation in the normal course as well. All right. So I've given the citation for the trustees for the time being. Once again, I cannot reiterate it enough. Trustees for the time being. Go to bed thinking of the trustees for the time being of a trust. Remember that. Then the state, if the state acquires property, we will describe it only as the Republic of South Africa giving away their rights. They're giving it away or receiving it. Mental patients, there is a nice description at the bottom of page 62 as to how one would describe it. Also in terms of your court order and or your letter of authority issue in terms of your court order, the master that issues a letter of authority. In a deed, always remember, depending on your document that you're drafting, your drafting has to be in correlation to the outcome that you are perceiving. So one has to make sure that you are drafting for the purpose of registration or not, and therefore have cognizance of the citation that then becomes important. So if a person is under curatorship, the grantee, the practice is not to vest the property in the name of the curator, but in the name of the person himself. In other words, it's the same as with a minor. I can receive rights without any description or representation we made mention of. And then we get to property clauses. So is there any questions on citations of persons or legal entities that I can quickly do before I move on to property clauses? Because that is next first foremost that I'm going to finish off with, and then I'm going to touch onto anti-nuptial agreements quickly for us. Right, so property clauses. So property clause is also one of those things that can really make or break any agreement or document that you have to lodge with the deeds office. There's certainly requirements that you have to adhere to, depending on whether it's an earth in a township. And if it's an earth, we say it's usually a freehold property. And depending on which province you are in, that will actually determine your description. So if you are practicing in Gauteng, we will say Earth 75 Oakdean Township, registration division IR. Depending on the allocation, can be IQJR, depending on the description of it in the title deed. Province of Gauteng, and then we have to cite the measuring as well in saying 99, and then you have to write that out. Once again, no abbreviation allowed, and square meters. If it is in another province, one has to adhere to that province deeds office requirements, or as they do it in that specific deed registry. So for instance, in Natal, you don't find townships. It will just be described in as, well, yeah, it will be Earth 75, say for instance in Belito, with no reference to a township. But it depends solely on the deeds registry that you are registering in. So always make sure where you are registering your property as to how your property description will look like. Yeah, it's a practice thing. Usually if I have to register documents in Natal, I'll phone my correspondent and say, listen, is my property description same as in the old deed, or is there any rectifications or changes in property description that is now applicable? Because those things also change, and especially with the description of the provinces, and with the properties as well. There has been quite a few changes if you're working with older title deeds. Then also there's a distinguishing factor between an agricultural holding and a farm in Gauteng. And remember, farms only get registered in the deeds office of Pretoria, no other deeds office. We always go back to Pretoria for the registration of a farm. Agricultural holdings is registered as a holding, and it has to state agricultural holdings at the back, no reference to township. Also registration division, province of Gauteng, and here's the catch now, measuring 1,7312 hectares. It has to be a comma, and there has to be 4 digits after the comma to describe it. So if it was just 1 hectare, we would say 1,000, and we would type out 0000 to make the 4 digits up. Yes, conveyancing and notarial practice overlap, and that's why it is nice to have if you have a bit of a conveyancing background, or if you can have some feeling of what gets registered in the deeds office. Otherwise, you may be a bit lost in notarial practice when you have to work on the specificness of the deeds office requirements. Let's have a look at the description of a farm quickly. A farm is described in as a portion of a farm, Elandsfontein. And you'll see that there's an abbreviation to a number 267. Usually we leave out that abbreviation and just say Elandsfontein 267. Also registration division, province of Gauteng. And then once again, the hectares has to have 4 digits after the comma. All right. Kim, you are welcome to contact me on my email. I will ask Dodo so that she can actually send it to you. I'll see whether I can contact you from my mail that I have. If anybody has questions, I'll just ask Dodo to give them my email. Don't worry about that. All right, then in respect of an undivided share, remember, I can share half, or I can sell half of my property. If I'm a full title owner, I can sell half a share, depending on the situation, but then I have to describe it as 1/2 share. Where there's more than one property in a deed, you have to describe both properties. So say for instance, I'm referring back to page 63, we're setting Earth 75 and 76 Oakdean. We cannot just say Earth 75 and 76. We have to say Earth 75 Oakdean Township, registration division IR, province of Gauteng, in extent, and then you say number 2. is 7618, and you go through the whole spiel with the extent to have a proper property description of two properties in your power of attorney as well as in your deed and your TDR or transfer duty receipt. Then you also have a power of attorney. There's just a small distinction quickly. We get a special power of attorney and a general power of attorney. A general power of attorney usually has a collection of powers that we're giving to somebody that needs to be registered. Special power of attorney usually only is pertaining to one specific action. So that will be specific to a specific property that we are transferring. Yeah, it's specific to certain matters only. So we're very specific then with a special power of attorney. General, we usually register and we use that as reference for public knowledge as well, therefore the importance. And then guys, I am going to touch on, yes, I see my background is fluctuating on my side. Just give me a sec. Can I ask everybody just for a moment of, I'll be back in a moment. I just want to change my location for a minute, if you don't mind. Adili, is it back? Better? All right. Okay, guys. So then we're on to anti-nuptial agreements. All right. So for anti-nuptial agreements, it's important that we actually can draft. So I'm going to start with anti-nuptial agreements by starting with your assignment that was given, because that is in the end what you're all going to be drafting for us is an anti-nuptial agreement. So if you go to page 89, yeah, let me just go back one page. Sorry, I'm just paging through for you. Yeah, so it's indeed on page 89 if everybody is on that page. So because of our time constraint, I'm going to quickly go through it, but if there's any question, I'll definitely go back to more detail to the anti-nuptial agreement when we start off next week. So anti-nuptial agreements is one of those things where it is a format that is important. You'll see that there is certain notes that's prescribed to an anti-nuptial contract when you look at the on page 91 as to how you should be doing your agreement. And that's the first thing that I said just now, is that if you are drafting, you commence in the middle of the page. This is one of those times where you commence in the half of the page and you'll start off with your H number. So you'll have an H because the deeds office endorses it with a number. So if we do any deeds office search, we'll have a H number reflecting against the name or ID. That means that there's an anti-nuptial agreement registered for that specific person in the deeds office. Next, we have a protocol number, which is important for us, the notary, because that will coincide with my register that I have. So my protocol register will have a number, say 2 in it, and I can see who the persons was that executed the specific document. But in my register, in my register, and then the protocol as such, I'll have a original signed document showing the document that was registered in the deeds office as such. So one just has to be sure as to the documents that you have and that you have originally signed documents. And remember, it's your protocol number from the top that you have. So it coincides with your register, and then you put an original in your protocol file where we have reference to it. Just refer back to your definitions on this. So your anti-nuptial contract, the heading of it is in the half of the page. So you move everything that you start writing to half of your page when you do this. So by the H, write in the half and then you start. Anti-nuptial agreement, so you can actually state there whether it's with accrual or without accrual, doesn't matter. The heading will not make a difference. We look at what the body then complies of. Important is the preamble to this, is that be it hereby known that on this day, we have to be specific with the day time, place that we are doing this, who is our notary acting on our behalf, or who are we? You put in your name there. So when you are drafting for the exams, I would suggest that you put in your own name and pretend that you are the notary at that stage with your LPC number so that we know that you are practicing attorney. Remember, that's one of the pre-requirements. Notary public by lawful authority, duly sworn and admitted practicing at Joburg, province of Gauteng. Remember, the commencement, very important. And then we start and say, who came and appeared? Because the notary has to certify and make sure who's the people that is, one, appearing in front of them, and they know and understand. And then secondly, their signatures usually that goes with that person. We have to make sure people entering into an anti-nuptial agreement, unmarried people, if they were previously married, we have to obtain a divorce order together with a settlement agreement just to make sure that all the compliances are met with regard to the Act. Remember, you have to comply with the Act. It doesn't help that you're entering into a contract and you're not complying with the Act. Somebody is still married. The Act does not allow polygamy to be dealt with in this instance for registration. Then have a look at the clauses as to what should be included. There shall be no community of property. Remember, everybody is considered to be married out of community of property with the applicable, with the accrual system being applicable unless it's specifically excluded. So you have to exclude it specifically once you are doing this. So depending on your instruction, this will then be altered to the way that you want it. So this is one, so there should be no community of property between the parties. Secondly, you will have no responsibility with regard to the debts of the other party, so it's excluded usually. And then we have a look at the community, there'll be no community of profit and loss between the parties, and then whether it shall be subject to the accrual system or not. And this specific instance that we are looking at, the accrual system is applicable. We haven't got any starting values at this stage on it. I'll go back to the starting values when I start on the front of this. And then with that in mind, we will go to clause 4 with regard to what we are specifying as a starting balance or the starting amounts. Remember, when we're dealing with accrual, important is a starting value. You can't start with a negative value. In other words, if our debts are more than our assets, you start on a null. That is how easy it is. If the clients already have certain assets to their names, then you'll have a starting value for everyone. It will be part and parcel of your registration of your anti-nuptial agreement. And you will actually register it with your starting values. In this instance, there's a separate statement that is prepared for this. You'll see that 4.2 makes provision for the separate statement in terms of section 1.6 or 6.1 of the Matrimonial Property Act for the registration of those initial amounts. People often start off with nil balances just because it's easier. But remember, when they enter into this agreement, they all love one another still. But when we start looking at this and disputing fact, then usually the dispute arises from the starting balance as to what did I have before I got married and what happened during the course of the marriage to that estate that I had built up prior or within the duration of the marriage. Very, very important. So that gives you a few of the ideas that you can put into your contract, your agreement, and then also what you can exclude specifically from your anti-nuptial agreement. All right, so I've now started at the back. So with anti-nuptial agreements, I'm going to go back to the start now for those people flipping. So sorry, I've moved from page 89 for those that has a load shedding problem, just to give a fast overview of what anti-nuptial contracts is about. Now I'm going back to page 65 for those still online. So what we are going to test you on with anti-nuptial agreement is that you have to know and explain the various matrimonial regimes, the formalities that's required, the registration process, the identities and description of the parties, how do you describe minors and the requirements thereof, what is the consequences of if the minors, if you don't have the assistance of guardians when they actually execute or sign, contents that is needed in this, define accrual. You have to be able to work out the accrual values. So we'll make it easy enough so that you can actually work it out. But in practice, we give it to an actuary to work out when we get to divorces where we have fights about the accrual. Then we understand the commencement values of the respective estates. We have donations between spouses. There's certain exclusions you can see in terms of that anti-nuptial agreement. The husband excluded any benefit from his trust that he got, and the wife, her retirement annuity was excluded from that starting values that we had. Then we have understanding of the assets that can form part of an anti-nuptial contract, a pactum successorum, or if we want a will condition being put into in an anti-nuptial agreement, and what is the effect thereof. How do we create a trust in an anti-nuptial agreement? How do we do a post-nuptial contract, and what's the purpose of that? Rectification and verification or variation of an anti-nuptial, and then understanding a declaration in terms of section 6.1, and then the cancellation and revocation of an anti-nuptial contract. And then we also have to identify and understand marriages in terms of civil union, and then Customary Marriages Act. All right, that all in a nutshell. So the first and foremost, when people get married, they're either getting married in community or out of community of property. It's only in the detail then that we have to make sure as to how we differentiate. So if you have a look on page 81 gives you a nice description of what it is, the benefits of being married in community of property or out of community of property with or without the accrual. That is mentioned. If you want an easy reference to how it works, look on page 81. All right. From there on, so we will start again. We go back to page 65. Community of property, no anti-nuptial agreement registered. It's when we get out of community of property that we look at the accrual or not. So we call it either the old regime where there is no accrual applicable, or whether we are married with the accrual then in terms of that deed that we register. And remember, this is a speciality of the notary. So all the conditions and the expertise that is expected of the notary will also be expected of you when you are drafting this. So what we find is that people don't know how to draft anti-nuptial agreements. Those things get lost, misplaced in their offices, and then these things have to be registered by virtue of court application. And we want to foresee that in all possible avenues. So if you can, this is the one thing where you really have to be really specific. Make sure that whatever you drafted are registrable. Because it's not nice to go back to your client and say, listen, I've made a mistake, I've lost it, we haven't drafted correctly, and you have to redraft. And in this instance, if your agreement is not registered within the 3 months or the 6 months period, then you have to bring a court application. So yeah, very important that we do it right the first time around. So on your first consultation with your client, you have to advise your clients on the operation and the consequences of the available alternatives. So for us, it's easy to say in community, out of community, accrual, not accrual, but for the person getting married, it's like giving them too much information. You have to sit down with them and actually explain to them what is the different advantages of each of the regimes as to what they want and what they don't want. What I've gotten in practice, and I see they make mention of it, is that you'll get people walking in doors say, can you just notarize this for me and register it? that is not the purpose of being a notary. You have to certify or actually make sure that whatever document you want to register as a notary has been drafted under your supervision, and that you have made sure that the people signing those documents have done so in front of you and that they understand the content. So important that you cannot just register something that's put under your nose, execute it, and then expect it to be registered. I think that is just making yourself or putting yourself at risk unnecessarily. So yeah, they also say being very emotional and psychological effects of a chosen matrimonial property system. I've spoken to one of our mediators in the last week who said that people don't enter into anti-nuptial agreements because they cannot face the consequence of discussing the different regimes, and often it's necessary to speak to the parties separately. And it does work because people feel that they can be more open as to the expectation and to the options that's available to them, and whether it's indeed to their benefit or not. And what I found with a lot of youngsters is that, you know, they'll have parents say to you, but you can't get married with the idea of getting divorced, and entering into an anti-nuptial agreement is sort of putting that idea there that we're getting married to get divorced. And that's why you have to explain to them as to what is the consequence of getting married in community of property. How are you getting married out of community of property? And is it beneficial to be married with accrual or without it? And in which instances, Simongile, I'll get to that just now. So for that matter, we have to be very diligent in our explanation so that the choice that's made by the client actually suits their circumstances and expectations as to what it will and will not entail. So we have to explain to them the operational working of each system. For instance, if you are married in community of property, the consent of the spouse is required. If we are married out of community of property, we can contract and transact as you like, except obviously if we want to transact together, then we get cited together. But this is some of the things that we need to explain. And in other instances, the question often asked by ladies who is executive for their homes, they will say, but who looks after me if I get married with no accrual? If something should happen to my husband or we should fight, get divorced, what then? And then you should be able to explain to them the benefits of either the accrual system and or not being married with that specific system at all. So you have to be able to ask and answer questions that is put to you by the clients as such. Yeah, so it just goes on to say as to the advantages of being married with an agreement. And I know there's a lot of people that will usually say you can't get married in community of property. But one cannot just merely discourage people to get married in community of property because of opinion. Depending on circumstance, some people will benefit better from being married in community of property rather than being married out of community of property, irrespective of the accrual or not. It just depends on what suits your clients best. But you have to be able to answer and answer the questions that's been asked to you. So if you describe the people in your, so we're drafting documents now for them with regard to this, the notary must know how to describe the person correctly in a deed or document, who must sign the documentation that is destined for the deeds office in this regard. Can you sign on behalf of the deceased person, minor or mental patient? Remember, we're dealing with an anti-nuptial agreement. It's a personal matter and it's a status matter. We're dealing with status. So it's really important that we know whether we can sign on behalf of other people and in which person or rights it will vest, or whose names the obligations are incurred in terms of Section 17(1) of the Deeds Registries Act. But remember, once again, this is an anti-nuptial agreement that we're talking about. So firstly, we're talking about format, then we're talking about content, and then we're talking about what suits your client the best. When we are dealing with immovable property in an anti-nuptial agreement, we can do different things. It's a vehicle for, well, people use it to say that, well, as a bequest, you can leave your belongings to other people in your anti-nuptial agreement. You can donate to your spouse certain property, depending on how you donate it. There is certain allowances that you can do in a year as to the tax provisions as well, Tax Income Act, as to donations that you can do between parties. But they also say for you that immovable property, real rights in immovable property and notarial bonds, which would upon transcession or registration form part of a joint estate, shall be registered in the name of both the husband and wife. All right. So always that is the relevance that we're working towards. But there's also removed from where we are when we are working with an anti-nuptial agreement. Remember, in terms of the Matrimonial Property Act, we are assuming that the properties are both unmarried, divorced, widowed, that there's no other marriage incurred, or they're not involved in any other marriage. Remember, the moment that you are involved in another marriage regime, then you cannot enter into an anti-nuptial agreement anymore. All right. So just a general rule relating to marriages in community of property, obviously there's no contract registered. You can't really have a joint or a separate estate, save and except for those things that is excluded from your marriage in community of property, inheritances, donations, things like that, or personal rights that you get. That would be in your personal estate when you have a marriage in community of property. Remember, so certain rights you can exclude them when you are married in community of property, no contract. Then we get to Chapter 3 of the Matrimonial Property Act, and this also applies to marriages in community, and then the marital status or the application has now gone. So there is no more application of a marital power as such. Then we look at Section 14. It assigns to the wife equal powers. You can dispose of assets in a joint estate, contracting of debts in a joint estate, and the management. The only problem then arises as to the consent. We need consent of the other spouse that didn't enter into that agreement, and depending on the outcome that we foresee, once again, we'll have to have a look as to the written consent and those formalities surrounding that. Then you'll see Section 16 is applicable when spouses refuse to give you that type of consent that's required, and that you can bring a court application for permission to enter into specific agreements. And then also legal proceedings. Married in community of property, you need the consent of another or of the other person in that specific marriage. Then, the important provisions of Section 15, you'll see that there's 8 instances that's provision for or acts written consent of the other spouse is required. Please, please, please give attention to those 8 acts of registration or the written consent that's required. It's clearly indicated there for you as to how you can and should be doing those type of consents that is required. You'll see some of them, you need the signature in writing and attested by 2 witnesses, and in others, you just need the consent of the other spouse. Just have a look at the formalities in each of those instances when you are actually encumbering then the estate of a joint estate. Also, the binding of yourself as a surety, being married in community of property. Remember, Section 15 deals with marriages in community of property and consents of the other spouse. We're looking out for other people's rights. How are we going to bind ourselves as a surety? That we need consent. It can be done by way of ratification, except if required for registration in a deed in the deeds office. It cannot be ratified. You need to get that consent on the document that you are registering. Otherwise, deeds office will not allow registration. You can have a look at Section 15.3. The ratification that needs to be given in terms, well, it needs not to be given in writing, and the ratification can be given just in reasonable time, but that's for 15.3. Then we have to have a look at section 15.6. We can do certain acts without obtaining of consent, but if they are performed by a spouse in the ordinary course of the business, trade, or profession, then what this be? Would you be your partnership? All right. So what would happen if a person performs a juristic act for consent is required in terms of the act without obtaining such consent? So it also sets out the consequence of not obtaining the consent of the spouse. Very, very important. So just have a look at that. Yeah, and then obviously also, like I've said previously, there's different reasons for people getting married in a different way. You just have to listen to your clients and take proper instruction when drafting. So then we get down to marriages out of community of property. Marriage without accrual system is a very plain agreement that you draft. Remember, format first and foremost, halfway down the page with your commencement and your final paragraph in a certain manner, but that you can see certain advantages that you get because of the regime is that, you know, some people, when it's a second marriage, they've built up an estate. When you're married out of community of property, obviously becomes in stage yours. You don't have to share any of the consequence, and it's a more preferable way of getting married in without the accrual. Yeah, and then obviously you cannot really force people because of the threat of insolvency to get married out of community of property. Not everybody gets or gets or goes down the road of insolvency, but it just depends on the circumstances. But yeah, this is really not a reason for entering an agreement or an anti-nuptial agreement, is the fear of insolvency. Yeah, marriage out of community of property, obviously you can buy and sell without consent. Yeah, and then you can have a look at women and their rights with regard to entering into anti-nuptial agreement without the accrual. Usually they're worried, should the marriage not last, as to what would be the consequence. And that then depends on what the contribution was during the course of marriage, and by way of a monetary valuation input on the well, yeah, on whatever contribution they have made to the household. So the accrual system is another thing. So most young couples today get married out of community of property, including or incorporating accrual system. And I think that it is fair and equitable for both of the spouses. And it's based on the assumption that both spouses will contribute equally and share equally in all the financial benefits that you may get from the course of a marriage. The fact that the wife does not earn an income does not mean that he or she is not contributing. Remember, these days we also get men being the house man, and then your contribution might be in the form of emotional or physical support, and then in the end, you may be financially rewarded for your contribution made in other ways to your estate or the growth of the estate during the course of the marriage. Other advantages of the accrual system, I'm on page 75. So advantages of the accrual cluster, it gives you the best of both worlds, that you can share in the benefits. If something goes wrong, you also are independent, that you can actually act on your own behalf. And there is the, well, the equal distribution of assets, yeah, that can happen. There's also disadvantages of the accrual system. But yeah, those merits has to be considered for every instance or circumstance. Remember also, a spouse only gets the benefit of an accrual at the end of a marriage, be it by death or divorce. And I always say that's when the content of your antenuptial agreement is important is by the end of a marriage. It's not during the duration of the marriage that we want to know, really. So if we're entering into any agreement, that's why no mention is made with reference to the accrual. We merely state that you are married out of community of property because you can act on your own behalf. And that's the benefit then of that. So if we get to date of death or divorce, then we usually are interested in how did we contribute to the growth of the communal estate, because there is a communal estate in the end. Then we have to have a look at the formula for calculating the accrual. And remember, this is important for purposes of the exam, just to know that if you start off your agreement or your antenuptial agreement, if you started off with a nil balance, then obviously it's an easier sum to make at the end of a marriage as to where we end, because it's an easier sum to make. Yeah, we leave it to an actuary in any event when we get to disputes, when we get to divorces, to actually work out the accrual system for us. That is really a difficult thing, because there's so many things, the CPRs that needs to be kept in mind with working out an accrual. Then the notary should be careful when advising the qualification of the accrual system so as to not to nullify. So a lot of people would like to say to their clients, listen, I suggest that your starting value should be 40,000 or your starting value should be 60,000. If a client's start off value is really a null, let it be null. If it's a zero because of a negative balance, let it be a zero. In the end, it is setting forth the real financial statement of affairs of both the parties entering into your antenuptial agreement that makes a difference at the end of the marriage. And that's why they're then fighting. Nobody's friendly anymore, and then they want to have what is rightfully theirs. So remember the accrual, if you don't want it part of the antenuptial agreement, it has to be expressly excluded therefrom. You'll see that in terms of section 3, the net accrual is shared equally by spouses on termination of the marriage. And then you'll see it is to denote a net increase of the value. So we're dealing with a net accrual and a net increase in the value of the spouse since the date of marriage. And that's why your starting values is so important. And they give you examples there as to how you should be starting it and ending it, and then the subtraction between the two, and that division then between the spouses of a 50-50 division when working out the accrual. They also give you a nice calculation there of accrual where commencement values were null, and how to then work it from there so that both parties can share in the joint estate or the value of the estate at the or the ending of the divorce. So then there's also the calculation of accrual where the commencement values were not null. Remember, if they are null, we can state that in our initial antenuptial agreement. We also can state the initial values in our antenuptial agreement. However, if parties feel that they are not sure as to the commencement values, they can also do a statement in terms of section 6.1 when they set out these values that will be part and parcel then of the agreement, but it's not registered as such at a deeds office. Remember, the registration of an antenuptial agreement is a public document. So anybody that makes inquiries with the deeds office can ask for a copy of that antenuptial agreement entered into by paying a fee to a deeds office. And then you can get a copy to see what was actually stipulated in that agreement. So it becomes a public document, and therefore one has to carefully consider as to the content thereof. So if one is an Oppenheimer or a Rupert, then most likely you will rather prefer having a statement in terms of section 6.1 negotiated rather than having your statement of financial affairs published to the world. But that is just an opinion that you can follow. But yeah, mostly we prefer to include our starting values in the antenuptial agreement, because then there's nothing left to chance. Because if there's no statement 6.1 and is left and never attended to after date of marriage, then it will be considered to be a 0. So one just has to be careful as to what is omitted and not in your drafting of your antenuptial agreement. So the accrual then, or the right to the accrual, is postponed to the dissolution of the marriage, and creditors cannot lay any claim therefore, or thereto, and it does not fall into insolvent estate of a spouse. Then have a look at section 4, which figures are omitted from determining the accrual of the spouse. In other words, there's certain provisions. So if you have excluded your income from your trust or from your annuity, then those figures are not included in your determination of the accrual in the estate or the growth. And then they also state here that the actuary will be employed in to calculate the CPI on the commencement values of each spouse, should same not have been null. So it just depends on circumstances as to how your calculations will be done on determination or when the marriage becomes or is ended there. All right, and then they also state here, so Simongile, to come back to your registration. So any antenuptial agreement has to be registered within 3 months of the execution thereof. And it has to be executed before the marriage. So yeah, so those are the 3 months and the 6 months. 6 months is usually for the statement that has to be concluded after that. So that is also stated in this initial values. So many people do not give enough consideration to the initial values, but it is important to have them stated. And then section 6.3, it serves as prima facie proof of such a value. Oh, I am going to take 5 more minutes. Is that all right with you, Keenan? Sorry to disturb. We have run over time with our, sorry, my connection error. Is that all right? Anybody else? I will recap next week because I want you to work through the modules or the questions that's asked. If there's a problem in the drafting, please ask me, or if you're not sure, because I know they give model answers, and then people are not always sure as to the reason for the answers. Okay, so we are back to the initial values. So when you draft your antenuptial agreement, please give enough time to consider the initial values in your antenuptial agreement, as it serves as prima facie proof of such value. If no initial value is declared, it is deemed to be null. This is also the case where the liabilities of a spouse exceeds his assets. In other words, you have more debt than assets. Then if you can't have a 0 starting figure, then we have, or not a negative, we have a 0, sorry. So you can't have a negative net accrual, you have a 0. In terms of section 7 of the Matrimonial Act, if a spouse is deceased or the deceased estate, we will work out the accrual the same way as if the marriage came to an end by divorce. Same then is applicable to that in the estate that is then, they can then lay a claim for that part of the accrual. Then Section 8 of the Matrimonial Act deals with the power of the High Court to order a division of the accrual by application. In other words, the marriage is not formally ended, but we need the accrual to be dealt with, and then on application, the court may consider an application to have the accrual paid out or the division of such during the course of the marriage. Then we look at Section 9. It provides the right to share in accrual in a patrimonial benefit which may be forfeited. In other words, we found it in a lot more of the older cases where people got divorced because of affairs that they were having, or they felt that there was certain things that had gone wrong because of people's fault or other people's fault, that they would ask for forfeiture of the benefits that they can get in terms of the accrual. So those rights can also be waived or they can be forfeited in terms of a divorce order. So one has to be careful, consider as to how you actually work that out. Right. Then there's only general provisions that's left, formalities that you have to put in. Like I said, it's a format thing with name, surname, that you have the commencement also with that. Although it's practiced that an ANC be signed before the notary in the same day, there's no objection that each party signs before different notaries on different days. So that can happen. If the one party cannot attend, maybe we have two notaries in the office. The one can sign before me on tomorrow's date, and the other one is usually the latter date that we will consider the date of signature. All right, for final execution, customary to have two independent witnesses be present. Remember, I can't have my document signed and then run off to my secretary to have it assisted or attested as a witness. They have to actually see to the witnesses, or the witnesses have to see the signature and sign in the presence. That's obviously what it says, that you signed and attested to in the presence of those witnesses. Those witnesses and the parties must have the contractual capacity. Minors should be assisted. And then the guardians or the parents at the time of the execution, those the parents must be, those are the ones assisting the minor. And then an ANC executed by a minor without the consent of his parent is invalid. Remember, we're already having discussions with ages beyond 7. Not that I say people will get married if they're beyond 7, but always just think of the consequence of can they act, can they not act, and therefore they have to be assisted by a parent or a guardian even. And then should the parent then refuse, or the guardian, then there's always the Commissioner of Child Welfare for the district in which a minor is resident to consent to the marriage. However, it has to be beneficial. They have to really think that it's beneficial that they should be entering into this anti-nuptial agreement. Where parties have entered into an anti-nuptial agreement and subsequent divorce and marriage even, so you get that people get married, they get divorced, then after a while they realize, like Liz Taylor of the good old days and Richard Burton, they get married again. You have to enter again into an anti-nuptial agreement. Otherwise, on the second round, if there's no agreement, you will be married in community of property. So, yeah, that is the one thing that one has to consider. Second marriages, you can't just fall back on an old contract being registered. The moment that you get divorced, then that marriage or that contract comes to an end, you have to enter into a new agreement on a second or further marriage to the same party. Remember, that's now on the same party. Then it's also with regard to, can I give somebody an authority to act on my behalf to actually sign a document in front of a notary when I'm entering into an anti-nuptial agreement? The question is yes. However, because of the intricacies involved with the signing of anti-nuptial agreements, it's preferable that both parties sign in front of the notary executing the document, so that the notary, if a dispute should arise, will be able to actually state that it was proper, that he firstly identified himself to the identities of the persons, that they did understand, that he explained the content of the anti-nuptial agreements to them, and therefore people signed. If I give power of attorney to somebody to sign on my behalf for entering into a contract, you are never sure as to the understanding of the person on the receiving end. So my agent might understand, but I may not. So it's always that confusion as to what happened between the agent and the person giving the instruction as to whether that was clearly understood then. Then due regard must be had to the provisions of the Deeds Registries Act. Remember this, you can draft the nicest agreement that you can possibly think, but if you don't adhere to the Deeds Office Registries provisions, they throw out your anti-nuptial agreement and it doesn't get registered. You have a problem because you have to go back to clients and have it either redrafted and re-signed, or you have to bring an application to have that agreement acknowledged, or that is put in place. So there's some things that you just need to do properly when you do it. Don't let it lie around. Don't let it fall in between other files. If you can get it executed and lodged the following day, then you do that, so that you don't have any of that responsibility of a execution or a deed that has been signed and executed but not registered. Remember, that is important. So the date of entering the contract is very important. It has to be executed before marriage, all right? It must be registered in the deed registry within 3 months of execution. So one, before marriage, registered 3 months after execution. And then remember, your statement in terms of section 6 or 6.1 should be then done within 6 months thereof. So if that isn't done, then we revert back with zero starting balance. So those 3 time limits you have to adhere to. Make note of it and make sure that you don't miss the opportunity to have it registered. And that's where we see a lot of court applications, is that people don't draft properly, and then in the end, they have to bring a court application either to register post-nuptial, and then they have to go through all the provisions of having that registered in terms of a court application. Then they just make provisions for the types of provisions that should be in an anti-nuptial agreement, or the usual ones. So you can just be very clear on it. I mean, if you have long sentences, contradictions may step in. Keep it short and sweet. State whether the accrual is applicable or not, excluded or not. What the accrual. So there's 6 steps basically that you have to follow. You exclude community of property. You state whether there's accrual system or not. If there's accrual, you have a starting value. And then if there's anything that needs to be excluded, you describe that. And if there's any donations, try and stay clear from trying to make your anti-nuptial agreement a will, because that is the one thing now where you'll be held accountable should something happen and you have to revert back to your anti-nuptial agreement for that. Also have a look then at the other types of clauses that may be found in anti-nuptial agreements. Also where the anti-nuptial agreement is concluded outside South Africa and couched in foreign language. In other words, it's drafted in another language. You have to have it accompanied by a sworn translation thereof. If you want it registered in our deed registries, same will still apply. You must have due regard to the tax implications. If you should register anti-nuptial agreement, no donations tax, payable on donations between spouses, transfer duty payable within 6 months. But this is, however, where we give to our spouse specific property. In other words, I say, I give to my spouse 75 greenstone as a marriage gift or marital gift, and that has to be registered, or has to be the transfer duty has to be paid within 6 months within that period. Then otherwise you'll pay penalties on that. So one just has to take those type of things into account should you wish to make donations or transfer property or give property, that you give adherence to the necessary acts applicable to those types of bequests if you make them in your anti-nuptial agreement. If it's specify immovable property, just have a due regard to that 6 months period that you have to pay your transfer duty within. So although the donation may be free of tax on the income tax side, you may have to be on the transfer duty side. If it is applicable, you'll pay penalties on the transfer duty. And then often the provisions of the capital gains tax also is overlooked when a donation is made. Remember, there's a difference between donating to my spouse within a specific year within the specific terms of the Income Tax Act, or giving property. We must just have adherence to that, because those tax implications are changed every year. And you did get it sometimes that people will say to you, but I haven't given my spouse this or that property or this or that amount this year yet. First check with SARS as to whether that will be free of any tax implications should you choose to then proceed with that type of donation. There has been instances where those type of donation has been taxed terribly, and I've seen my clients pay duly for that, but that's then a choice. You must, yeah, sorry, I'm so sorry for overstepping this. I'm going to finish in the next minute. All right. And then, is there any questions so far? Because what I've just said is all taken up on page 81. And then it's only post-nuptials that is left. And then just remember that people, or majority age is 18 years and no longer 21. And then I've just done the repercussions of donations and settlements. And then post-nuptials is the only other thing that one needs to take notice of, that should something have gone wrong as to how you go about registering a post-nuptial agreement. And then often that you cannot, and that you cannot rectify mistakes in antenuptial agreements as such. Any questions? So there is some assignments for you. So you'll see that there's assignment 1 at the back of this specific module. Yes, you can, I think, give it a go and try and first do it on your own. And then thereafter, you'll see there is a model answer for you just to check whether you have understood the content of what we have discussed. But if there's any questions, please feel free. I will give some extra time to anti-nuptial agreements specifically when we start next week. And that is me for now. Anybody? Any questions? All righty then. So that is your assignment. It's a pleasure. I hope that it didn't go too fast. I'm really sorry about the connection issues that we had initially. If there's any other question that you might have, I will give some more attention to that, to anti-nuptial agreements specifically. The rest, you sure. What I'll also do for you, Landi, is I'll try and put in an extra slide or so for things that I think it's important, especially on the drafting side, because with notaries, it's important that you can draft. So it is format and citation and then drafting. Yes, I will do that for us for next week. I'll just give us a bit of a feedback on those by giving you formats and some things that you can look at, just highlighting what I've said tonight. All right. Thanks a lot, guys, and thanks for sticking with me on my connection problems. I'm sure we've sorted out most. Yes, and then I'll see you online next week, same place, same time.